Morning. Before we go on the record, I'd like to just make sure we have our court reporter with us. Appears we do. Do any of the parties have any matters that we need to discuss off the record before we go on?
Honor,
Ms.
I
Brennan.
have one question. I mentioned an exhibit yesterday. I do have that and I sent it around. I know you were busy in the admin meeting, so I don't know when you want to consider that, if at all, but that has been sent around from Montgomery County this morning.
Okay. I haven't received anything yet, but we'll receive it from our assistants at some point during the day, and we'll. You seek to move that item into evidence, is that right? The exhibit?
Yes, and Pepco has indicated that they don't object to that stipulation.
Okay,
that's correct, Your Honor.
Thank you, Mr. Seegers. We'll take care of that after the commissioners receive it and have a chance to take a look at that.
Thank you, Your Honor.
Anything else?
Yes, Mr. Chairman, I just wanted to let you know I have spoken with or heard from Mr. McAuliffe. He will be available to testify on Friday if the commission has questions for him.
Okay. I do want to have a video.
Okay. Do any of the parties know at this point whether they seek to cross Mr. McAuliffe on Friday?
The company has no questions, Your Honor.
Okay.
OPC has no questions, Your Honor. Sorry, OPC has no questions, Your Honor.
AOPA has no questions, Your Honor.
Montgomery County has no questions, Your Honor.
Neither
Right.
does Prince George's County, Your Honor.
Thank you, Ms. McGee. Ms. Brennan. Ms. Music, questions
town-
for?
No, Your Honor. The town of Kensington has none.
Okay. Mr. McAuliffe then is excused. Anything else before we go on?
Thank you, Your Honor.
Yes, Your Honor. If I could just confirm that the commission did not have questions for OPC's witnesses, Courtney Lane or Jerry Mirzwa, and that they're excused.
And none of the parties had crossed for those two witnesses?
I don't believe so.
Okay. Lane and Mirzwa. We'll
Yes,
confirm
they are
that.
Sorry?
We'll confirm that by the end of today. I'd like to give the commissioners an opportunity to cross-check that.
Certainly. Thank you.
Thank you. Okay. Any other off-the-record items? Morning, Madam Court Reporter. Are you ready to begin?
Yes, Mr. Chairman, I'm ready. Good to see everybody.
Thank you, Linda. Okay, we'll go on the record. Good morning. This is a continuation of case number 9655 in Pepco's multi-year rate application. Are there any preliminary matters that we need to address on the record? Seeing
Your
none.
Honor.
Oh, Ms. Ryan, yes.
Yes, I just wanted to take a moment and clarify the status of a couple of documents that OPC used during cross-examination yesterday, specifically exhibits 12, 13, and 14. And first, I just wanted to confirm that 12 and 13, which are transcripts of the evening hearings, are part of the official record of this case.
Yes, those court reporter transcripts are part of the record, correct?
Okay. And with respect to exhibit number 14, which is the written public comments, which are available on the commission's website and maintained by the commission, are those a document that the commission can take judicial notice of?
Yes. Yes, those are in our possession. Those were either electronically filed or mailed and scanned into this case jacket. So you can take notice of that.
All right. Thank you, Your Honor. I just wanted to make sure that I was clear on that.
Okay, seeing no additional matters, Pepco may call its next witness.
Thank you, Your Honor. At this time, the company would call Matthew Bonikowski to the stand.
Thank you. If the witness could please raise your right hand and prepare to be sworn in. Madam Court Reporter, you on mute and then off mute. You're muted again.
Sir, do you swear and affirm under the penalties of perjury that the testimony you're about to give and the matter now pending is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Your witness, Mr. Seegers.
Thank you, Your Honor. Could you please state your name and your position for the record?
My name is Matthew Bonikowski. I am a senior rate analyst with Pepco Holdings.
Okay. Do you have before you the pre-filed direct testimony of Peter R. Blazunas filed on behalf of Pepco in this matter, which has been pre-marked as Pepco Exhibit 33, consisting of 44 pages and 13 exhibits?
Yes, I do.
Are you adopting this testimony as your own?
Yes, I am.
Do you have any corrections or modifications to this testimony at this time?
No, I do not.
And if I asked you the same questions today, would your answers be the same or similar?
Yes, they would.
Do you have before you the errata to the direct testimony of Peter R. Blazunas filed by Pepco on January the 11th, 2021, which has been pre-marked as Pepco Exhibit 34, consisting of 7 pages and 11 exhibits?
Yes, I do.
Are you adopting this testimony as your own?
Yes, I am.
Do you have any corrections or modifications to this testimony at this time?
No, I do not.
And if I asked you the same questions today, would your answers be the same or similar?
Yes, they would.
Do you have before you your pre-filed rebuttal testimony filed on behalf of Pepco in this matter, which has been pre-marked as Pepco Exhibit 35, consisting of 30 pages and 11 exhibits?
Yes, I do.
Do you have any corrections or modifications to this testimony at this time?
Yes, I have 2 corrections.
Okay, and what would those be?
So in my rebuttal testimony, the first is on page 14. On line 12, there's a reference to footnote 12. Footnote 12 should be deleted.
Okay.
The second correction is on page 29. In table 5, the first date is listed as May 24th, 2021. That should be corrected to June 28th, 2021.
Okay. And with those corrections, if I asked you the same questions today, would your answers be the same or similar?
Yes, they would.
Do you have before you the errata filing submitted by Pepco on April the 2nd, 2021 in this proceeding, which has been pre-marked as Pepco Exhibit 36C, of which your portion consisted of 1 exhibit?
Yes, I do.
And for the record, Your Honor, this was mislabeled on our exhibit list. It is not confidential, so we would like to label this as Pepco Exhibit 36. Do you have any corrections or modifications to this submittal?
No, I do not.
And finally, do you have before you the errata filing submitted by Pepco on April the 8th, 2021 in this proceeding, which has been pre-marked as Pepco Exhibit 37, which consisted of 2 exhibits?
Yes, I do.
Do you have any corrections or modifications to this testimony at this time?
No, I do not.
Okay. At this time, Your Honor, I would like to move into evidence Pepco Exhibits 34, 35. I apologize. Exhibits 33, 34, 35, 36, and 37.
Hearing no objection, Pepco Exhibits 33, 34, 35, 36, and 37 are moved into evidence.
Thank you, Your Honor, and the witness is available for cross-examination.
We will begin the examination by staff counsel.
Mr. Spivak, I believe you may be on mute.
You're right. I just thank the chairman and say good morning to you.
Good morning.
Okay. Thank you. Shouldn't be too long here. Now, you are the person basically sponsoring the effective BSA adjustments to rates. Is that right?
Yes, that's correct.
Okay. Now, regarding the effective BSA adjustment to rates, these are dependent on billing determinant forecasts, are they not?
Yes, they are.
Okay. For example, if an alternative forecast for schedule MGT-LV had a higher sales forecast with no change in the customer count forecast, the effective BSA adjustment to schedule MGT-LV would be different, would it not?
Yes, it would change.
Okay. And is it true that if a class had the same average usage per customer, meaning the same kilowatt hour sales per customer, as the historic test year in the prior rate case, there would be no effective BSA adjustment for that class?
So I would say it's more than just kilowatt hours. If both KWH and demand forecasts were the same as the historic test year, then yes, there would be no effective BSA, because the effective BSA is essentially the difference between the BSA targets that are based on the historic test year from the last rate case and the company's forecasts in this proceeding.
Okay, and with that caveat about demand, would that be true of the residential class or no?
Residential doesn't have a demand component to their charge, so for residential, there would be no caveat there.
Okay, thank you. Okay, going to schedule MJB R-6 from your rebuttal testimony. Let me know when you're there.
Yes, I'm there.
Okay, and right now I guess we're on page 1. For schedule MGT-LV, you are proposing a rate, year 1 volumetric rate of 2.11 cents per kilowatt hour, and the current rate is 1.682 cents per kilowatt hour. Is that correct?
Yes, I see those numbers.
Okay. And would you agree, subject of course to the fact that this is lawyer math, that this is basically a 25% increase in the volumetric rate?
Subject to check.
Okay. And you are proposing to offset a portion of that increase through rider ERR, correct?
Yes, that's correct. Rider ERR in rate year 1 would offset the portion of that increase that's related to the incremental revenue requirement in rate year 1.
Okay. And that offset is, I guess, 0.147 cents per kilowatt hour?
It would be 0.147 cents. Oh no, I'm sorry. Yes.
I think we have the same number there.
Yeah, we do. 00147.
Right. Okay. And would you agree that, subject again to my lawyer math, the effective rate year 1 for schedule MGT-LV is 1.963 cents, and that this represents a 17% increase in the effective volumetric rate for schedule MGT-LV customers?
That sounds right.
So that these customers will see approximately a 17% increase in their volumetric rate under your proposal in rate year 1, correct?
That is correct.
Okay. For schedule GT-LV, you are proposing a rate year 1 volumetric rate of 2.150 cents per kilowatt hour, and the current rate is 0.1746. Do I have those numbers right?
Yes, I see those numbers.
Okay. And once again, subject to lawyer math, would you agree that this is a 23% increase in the volumetric rate?
Subject to check.
And again, you're proposing to offset a portion of that increase through the rider ERR?
That's correct.
And the offset is the same as it was for MGT-LV, that is 0.147 cents per kilowatt hour?
Yes, that is right.
Okay. And would you agree that, subject to math again, the effective rate year one for schedule, rate year one increase for schedule MGT LV, excuse me, for GTL LV is 2.004 cents per kilowatt hour, and that this represents a 15% increase in the effective volumetric rate for the scheduled GTLV customers.
Subject to check.
And would you agree that under witness Hoppett's proposed effective BSA cap, these effective rate changes would be limited to 10%?
So yes, staff witness Hoppick, as I understand it, has proposed to cap the volumetric rate impact related to the EBSA at 10%. I just want to expand on that a little bit. The impact of that is that base distribution rates would not recover the incremental revenue requirement that the company is proposing or that the commission would approve. A portion of that incremental revenue requirement would be deferred into the bill stabilization adjustment and paid over future months or years, depending on the current amount in that deferral balance for each rate class. So customers would pay, in effect, higher BSA charges for longer under staff witness Hoppick's proposal.
Okay, so the effect then would be essentially to stretch out those payments in a future period.
It would, and in so doing, the company, because base distribution rates would not recover the revenue requirement approved in, let's say, rate year one, the company would not have the opportunity to earn in real time those approved revenues. There would be a lag built in to the revenue recovery.
Okay, thank you. Okay. Pepco is proposing to offset parts of its proposed year one rate increase because of COVID-19. Is that correct?
Yes, that's correct.
Okay. Given the ongoing pandemic and Pepco's desire to limit rate increases because of the pandemic, you nonetheless consider a 17% increase in volumetric rates reasonable?
So I believe that in any rate case, it's essential that the base distribution rates that are approved collect the revenue requirement in that case. In rate year one, the base distribution rate should approve the revenue requirement that's approved in rate year one. I think that that's reasonable. And in this case, we have proposed to do exactly that, to adjust the volumetric rates in rate year one to ensure that the company's revenue requirement that would be approved by the commission could be collected in that year.
Would you say a 17% increase conforms to the principle of gradualism?
I believe that this adjustment is consistent with how the commission has traditionally handled revenue annualization adjustments and BSA adjustments in prior rate cases. And I think that the company's proposal is consistent with the principles of cost causation and gradualism. And in particular, this was spoken to in witness Blazunas' direct testimony in how incremental revenues were allocated amongst the various rate classes.
Okay. Can we go to your rebuttal testimony, please? And we'll start on page 5.
Give me a moment.
And when you get there, we're going to look at the sentence beginning on line 20.
I'm there.
Okay. Now, you've written this, that sentence states that these expanded inputs allow for a more targeted allocation of the revenue requirement to both under and over earning classes. Now, by the expanded inputs, you're referring to the 3 items directly above that sentence. Is that right?
That's correct. So the company has, in this proceeding, proposed a 4-step revenue allocation methodology, and that has a few specific inputs. There's a defined UROR threshold above which customers would receive an allocation in, I believe it's the second step. So sorry, the first criteria is the UROR threshold above which customers would be excluded from any incremental revenue requirement increase. The second step is a bound around 1.0. It's a plus or minus %, around which customers would receive the system average increase. And then there's a third input, which is a multiplier to the system average for under-earning classes. And that, to my mind, that's where the real value is in the four-step methodology. That under-earning multiplier is easily comparable across rate cases. And I see that as a significant improvement over the traditional two-step method, where the amount of the first step allocation is rarely directly comparable across rate cases.
Okay, well, you've anticipated my next question. Excuse me. But first, now I know your use of the term traditional as a modifier for two-step method, and you use that term because that is in fact how the commission has generally done it and approved doing it for quite a while now. Is that not the case?
So the commission has previously used both the two-step and the four-step in Pepco rate cases. The four-step methodology was used in Pepco's last settled rate case.
Okay, thank you. And am I right in surmising that the result of all of this is that under-earning classes get a larger increase and over-earning classes get a smaller increase? Is that correct?
That is, so when comparing my proposed four-step methodology with my proposed inputs against staff witness Hoppeck's proposal, that is correct. I would note the four-step is a flexible approach with that multiplier to under-earning classes. I believe witness Hoppeck certainly would have been able to produce a different allocation, but still using the four-step methodology to change the proportion of revenues assigned to under-earning and over-earning classes.
Okay. Okay. Now, speaking of that multiplier that you mentioned a moment ago, you list that in the table on the following page 6 for a number of Pepco's recent rate cases. Is that right?
Yes, that is correct.
Okay. And can we take a look at that table for a moment?
Sure.
Okay. Now, I note that the resulting for case 9418, which is 1.13 multiplier, which is the same as Mr. Hoppeck's result in this case. Is that correct?
That is correct. Although again, I would note that in the two-step methodology, that 1.13 is an output, as opposed to under the four-step, that's an input. So it becomes a direct control lever.
Okay. And also that in case 9443, the multiplier is 1.12.
Yes, that's correct.
Okay. And that's just one unit below Mr. Hoppeck's again?
It is 0.01 below 1.13.
Right. Right. Okay. And let's see. 9336, the result was 1.16.
Yes, that's correct.
And your average is 1.17, correct?
The average is 1.17 because this is an average of the past 4 Pepco distribution rate cases in which there was a revenue requirement increase. And in case 9602, the multiplier to under-earning classes was 1.27.
Okay, and 9602, was that case settled?
Not to my knowledge.
Okay, can we move on to page 10, please?
I'm there.
Okay. And here's where you talk about the effective BSA.
Yes.
Okay. Now, I'd like to note from the outset, the BSA itself has a 10% cap, does it not?
Yes, the bill stabilization adjustment has a 10% cap.
And you have sentence, the two sentences beginning at line 13 of page 10.
I'm there.
Really, actually, we can take the one sentence beginning at line 15.
Okay.
You're recounting staff witness Hoppett's argument there.
Yes, I am.
Okay. Witness Hoppeck is not incorrect in these two assertions, is he?
Witness Hoppeck is correct to my knowledge that in BGE's MYP, they called them Rider 25 adjustments. They're effectively the same as what we have labeled as EBSA adjustments. Those adjustments did not exceed 10% for any rate class, although I would note that our methodology in calculating the EBSA is no different from the methodology that BGE used.
Okay. All right. Going to page 12 at line 14. You have the sentence, the EBSA, the effective bill stabilization adjustment, in contrast, is a component of the company's rate design methodology and is used to ensure that new base distribution rates collect commission authorized revenues.
Yes, I see that.
And is not subject to any cap. Do you have any kind of commission ruling to the effect that an effective BSA adjustment, an adjustment of this nature, is not subject to any cap?
So I would have a couple comments. There has been no affirmative, no explicit commission determination either way. This is the first rate case in which we've used the terminology EBSA because this is our first forecasted rate case. Although I would note that in traditional historic test year rate cases, there's a very similar adjustment. It shows up in the compliance filing as a BSA annualization line item. And that has never been subject to any cap. And it is my understanding that in prior rate cases, those adjustments have exceeded 10% for some rate classes.
Okay. So your position on that is that the commission has not made any affirmative ruling on this this point, but essentially by allowing it in historic test year rate cases, that is the precedent, that there's no cap.
That is my position. I believe that our proposal is consistent with that commission precedent.
Okay. Now, okay, now the effect, going back to that sentence, the portion that says that it used to ensure that new base distribution rates collect commission authorized revenues. Now, it does this regardless of sales, doesn't it?
Can you clarify what you mean regardless of sales?
That is essentially the adjustment is made to compensate for any under or over collection sales. Is that right?
So what, and let me take a step back. What the EBSA is doing, it's basically moving our current authorized revenue forecast into base rates. So the EBSA is calculated as our forecast customer counts for BSA classes multiplied by the BSA customer revenue per customer targets approved in case 9602. That's the amount that we're authorized to earn for each customer. To the extent that over the course of the MYP, our forecast revenues at currently approved rates wouldn't recover that, there would be a BSA adjustment in the future. And so what we're doing through the EBSA is adjusting our proposed rates to zero out that future BSA deferral balance, future additions or subtractions made to that balance, so that the current authorized revenues based on 9602 BSA rates are being collected through base distribution rates.
Okay.
I hope-
Is it fair to state that both the BSA and the effective BSA are mechanisms to keep the company whole and ensure that it can receive its authorized revenues?
Yes, I would agree with that.
Okay. Moving on to page 14, up near the top. You note that the company applies a target revenue adjustment to non-BSA classes.
Yep.
That's essentially serving the same purpose as the effective BSA, is it not?
No, it is not. That is a distinct adjustment.
It's applying to this class, but it's doing the same. It's serving the same purpose, isn't it?
No, so the effective BSA that's applied to BSA classes, that's a true up because our current approved revenues don't match the revenues we'd receive from tariffed rates. And that's based on the case number 9602 rates and BSA targets. For a non-BSA class, our forecasted revenues are our forecasted billing determinants multiplied by our currently tariffed rates. So our tariffed rates do yield exactly what our forecasted revenues would be for that class. What the target revenue adjustment is adjusting for is only the incremental revenue requirement in this case. And I have a table here, but I'll just kind of generally summarize what's happening. So in rate year 1, for Schedule SL, just as an example, there's an incremental revenue requirement assigned, and we increase rates to collect that. In rate year 2, we're forecasting that billing determinants will drop slightly. And so the incremental portion that we added in rate year 1 is no longer collecting that full rate year 1 incremental revenue requirement. It's shown in this table, we would be about $5,000 under recovering because billing determinants have come down. And so what the target revenue adjustment is doing is it's slightly adjusting up the rate year 2 rates so that on whole, the total revenue requirement is still being collected.
Okay, thank you. I think we're just about done. I have one more bit of questioning here. Can we go to page 24 of your rebuttal testimony? And you are talking about witness Hoffick's recommendation that the company provide an annual, essentially totaling and a statement regarding BSA revenues. See that?
Can you refer me to a specific line number?
Okay, the very first paragraph there. You're just recounting witness Hoffick's recommendation.
Yes, that's accurate.
Okay, and he's asking that the company essentially provide an annual report on the BSA revenues. Is that a fair summary?
With specific criteria. I mean, he lists in his testimony a number of data elements that he would like to see included in the annual informational filing.
Now, okay, that's accurate. Going down to the next paragraph there, you state your objections to the proposal, and your first objection, as I see it, is that the company already provides the rider BSA revenues in monthly reports.
Yes,
is that
that's
right?
correct. Yep.
Okay, so the company has the monthly data in its computer systems, doesn't it?
We do, yes.
All right. So for the company to create an annual report, it's simply a matter of totaling data that's already in its system, is it not?
The company certainly has the ability to provide this information. The intent of my testimony here, and it is my belief that this just isn't the best forum to address this request. I think this conversation would be better served in a working group where all parties could voice what data elements they would see value in, and then the commission could make a determination off of that. I would note that BGE filed an earlier MYP, so they'll be hitting their annual informational filings before Pepco will. So I think there will be lessons learned and adjustments that we can make based on either the discovery they receive in that proceeding or comments received there.
Okay, fair enough. All right. Thank you, Mr. Bonikowski. That's all I have.
Thank you.
Any other party wish to cross-examine this witness? Hearing none, Mr. Seegers, do you have any redirect?
Very briefly, Your Honor. Mr. Bonikowski, do you recall being asked numerous questions by staff counsel regarding the EBSA?
Yes, I do.
And if I heard you correctly, did you state that if a cap is placed on the EBSA, then the company would not be able to collect its revenue requirement?
Within the rate year that revenue requirement was approved, that's correct. We would not recover those revenues.
Okay. If a cap were to be placed on the EBSA, are there any measures that should be taken to mitigate the company's inability to collect its revenue requirement?
Yes, to the extent that the commission does approve a cap on the EBSA, I would strongly recommend that the actual BSA revenue per customer targets in this case be established based on uncapped revenue and rate impacts. And what this would essentially allow is a real-time true-up of the BSA deferral balance. So any under or over recoveries related to that EBSA cap would flow through the BSA mechanism in real time.
And Mr. Bonikowski, do you know if excuse me, do you know if commission staff has taken a position on the proposal you just outlined?
Yes, my understanding is that commission staff is supportive of the proposal as I just outlined it.
Thank you very much. Thank you, Your Honor. I have nothing further.
Do commissioners have questions of this witness? Commissioner Herman.
Thank you, Mr. Chairman. Good morning, Mr. Bonikowski. Nice to see you.
Good morning. Nice to see you too.
So I want to talk a little bit about the effective BSA, which is granted a bit complicated. You said that that it would create lag. Did I hear you? If you put a cap on it, you would end up with what we've called regulatory lag, right?
That's correct. Yes, if that EBSA impact is capped.
Okay. And are you suggesting that there should be no regulatory lag whatsoever?
My suggestion is simply that distribution rates in this proceeding should afford the company an opportunity to collect the revenue requirement approved in this proceeding. The bill stabilization adjustment itself would still continue to serve as a retroactive true-up mechanism, and there's certainly lag associated with that mechanism, and that would remain unchanged. But I believe that rates should be set to afford the company an opportunity to earn its approved revenues.
Right. So I was going to say that. I was going to bring that up. The current BSA, which the company is proposing to continue, creates regulatory lag in some instances, does it not?
To the extent that actual billing determinants differ from forecast, yes, that's a retroactive, and it's on a 2-month lag, and then there's a carry balance depending on the size of the adjustment.
Right. So you also mentioned that the methodology that you used to develop the EBSA was no different for BGE, but I think what Mr. Spivak was getting at was that the results are so different that you end up with these much larger swings. and that Mr. Hoppick is trying to address those large swings. So why do we have larger swings in the Pepco case and not the BGE case?
So I can't speak to the specifics of BGE's case or their forecasts. I can just state that, you know, methodologically how we calculated these, that this is based on the forecasts, forecasted usage in our MYP, and that forecasted usage in this case has changed relative to the historic usage that was the basis for the case number 9602 BSA targets that were implemented. And so since there's been a change in actual customer usage, that's showing up through the EBSA.
Mm-hmm. Okay. So let me ask you on a different subject. How many errata were filed with the various pieces of testimony associated with you, and you've adopted Mr. Blazunis's testimony? Was it 3?
Yes, in total it's 3. There was 1 to witness Blazunis's direct, and there were 2 to my rebuttal testimony.
Right. So explain to me what happened with the large change with Mr. Blazunis's testimony that resulted in an extension in this case.
Sure. So the primary driver here was we identify. So let me kind of start from the beginning. I think this was kind of early December that we identified this issue in responding to a staff data request. We noticed that there was a discrepancy in the Schedule R and RTM forecasts. And what had happened is there was a transposition error between RTM and RTOUP, which is they're both time varying rates, but one is a residential time of use pilot, the other is the residential time metered rate. Those two numbers were transposed for several months, and it resulted in the forecast being incorrect for those two classes. There was also a much smaller issue or item where where KWH was being allocated using a 14-month average instead of a 12-month average, but that had much smaller implications on the company's forecasts. We identified both of those issues in, I think it was on or about December 11th. We were first made aware of those. Took 2 or 3 weeks identifying and isolating how to correct those, what the correction should be. And then we notified parties through a data request, an update to voluntary DR1-5, and provided the updated billing determinants there.
Okay. Now, I believe it was Mr. Oliver suggested that on rebuttal, you made significant changes to your schedules, and that those changes were could have been made earlier, or could those changes have been made earlier? And if so, why weren't they?
So I think that there were 2 items that Mr. Oliver was referencing. The first was the structure of our proposal shifted. So on direct testimony, we had proposed to directly offset the distribution revenue increases as opposed to running them through a rider, as we did on rebuttal testimony. The answer as to why we didn't include that earlier, that was based on the results of the BGE order. And so when that BGE order came out and we saw that the commission had directed all offsets to be run through a rider, we adjusted our proposal consistent with that recommendation.
Let me stop you before you go on to the next one. Let me ask you, did you let the parties know you're going to do that? Because your rebuttal testimony wasn't filed until March 31st, and that order was available at the end of December.
I don't recall whether we responded to discovery about this. At this moment, I do not recall if we had socialized that.
Okay, sorry to interrupt, but I wanted to get that question in before we moved on to the next issue.
Of course, yes. The second item that Mr. Oliver was referencing were the line items for the effective BSA in my rebuttal exhibits. Between direct testimony and rebuttal, those did change significantly, but that was due to a formula error, a cell reference error that was the cause of my April 8th errata filing, that final errata filing. Upon correction of that cell reference error, there is not a significant change in the effective BSA adjustments in my rebuttal filing.
Okay. So the last errata filing was April 8th. Was that the last filing?
That's the last errata filing that impacted my testimony. I'm not aware if there were other errata filings after that for other witnesses.
Okay. Thank you very much, Mr. Bonikowski.
Thank you.
Thank you, Mr. Coburn.
Commissioner Linton.
Thank you, Mr. Chairman. And good morning, Mr. Bonikowski. I actually had a question to follow up on the last line of questions that counsel for staff raised regarding your response to Mr. Hoppe's suggestion that some additional information be included in the annual filing. You stated during your response to Mr. Spivak that the company had the information in their systems, specifically related to the BSA. Mr. Hoppe also suggested some other analysis and information. Does the company have access to that information as well?
I don't have Mr. Hoppe's specific recommendations in front of me. My general understanding is that we do have the information that he requested, but I don't know the format that that's in.
Okay. This language is on I believe it's page. System's moving slow here, but I believe it's page 24 of your rebuttal testimony.
I have a summary of the items. I don't have the recommendation in his words though in front of me. But yes, the information that I summarize, which is BSA revenues, forecast and actual customer counts, KWH sales, billed demand, and weather normalized sales. This is for future periods, so we don't have it right now, but we would have that information at the time of the filing.
Okay. All right. Thank you. So why should the well, in response to Mr. Spivak, your suggestion was that there's a couple of ideas. One was to either wait to see how the BGE reports come out first, or perhaps allow the PC 51 working group to look at it. And I guess in the long term, your last suggestion was that the staff could submit data requests to the company. As you know, one of the concerns the commission had, and it was a pillar of this multi-year rate plan approach, was to make sure that asymmetry of information was available, but also to make sure that we have able to proceed with some administrative simplicity, not to complicate the staff's work in reviewing these particular plans. So I guess the question I'm struggling with here is why these additional steps that the staff should have to go through if the company has the information? I understand that if there's questions about format, we can figure that out. But if the company has the information and the staff is recommending that it be provided to them, and I believe in Mr. Hoppe's testimony, which is summarized on page 2 of his direct, he states that the staff would like to have an Excel spreadsheet, so that way it's easily accessible for them. So why is there some I won't call it resistance, but why is there some pushback on the staff's request?
So my opinion on this, and the reason that I stated that I felt his recommendation was unnecessary, is it's my belief that a working group would just provide greater input from all parties. In addition to just staff, it would be a more inclusive forum, so that we could make sure that we're satisfying the needs of all stakeholders, and we can minimize future discovery that may be may be coming. And I did mention that BG would be the first to file their MYP annual informational filing, and we would certainly take learnings from that to the extent that we see common data requests being filed. We can have that information, prepared and ready and available for parties. But the basis of my recommendation was just to allow input from all parties. I would note, I don't make a recommendation against providing this information. It was more just a procedural question of whether this rate case is the best opportunity to amend that AIF filing requirement, or if that's more of a process question that would be better kicked to a working group.
Okay, so just to be clear then, the company's not opposed to providing the information, but it's more a question of how the process will work forward so the company can provide the information to everybody in a proper and timely manner.
Yes, and what data items to provide. But yes, we're certainly, and we're not opposed to providing the data items that witness topic had outlined.
Okay. All right. Thank you. Thank you, Mr. Chairman. That's all I have.
Thank you. Do any of the council have any questions based on the resulting responses from the witness? Hearing none, the witness is excused. Thank you.
Thank you.
Pepco may call its next witness.
If you could give us a moment, Your Honor, I'll be switching out with Ms. Hassan, who's going to be sponsoring Mr. McKenzie.
Good morning, Your Honor.
Ms. Hassan, you may call your witness.
Thank you. The company calls Mr. Adrian McKenzie to the stand.
Mr. McKenzie, could you please raise your right hand?
Sir, do you swear and affirm under the penalties of perjury that the testimony you're about to give in the matter now pending is the truth, the whole truth, and nothing but the truth?
Yes, I do.
You're a witness, Ms. Hassan.
Thank you. Good morning, Mr. McKenzie. Could you
Good morning.
please state your name and business address for the record, please?
My name is Adrian McKenzie, and my business address is 3907 Red River Street, Austin, Texas, 78757.
Wonderful. And do you have before you the document entitled The Direct Testimony of Adrian McKenzie, which has been previously marked for identification as Pepco Exhibit 25?
Yes, I do.
Wonderful. And do you have before you the document entitled The Rebuttal Testimony of Adrian McKenzie, which has been previously marked for identification as Pepco Exhibit 26?
Yes.
And do you have any revisions or corrections to either Pepco Exhibit 25 or 26?
I have one correction to Exhibit 26. That's on page 58, line 11. And this is just a typographical error. In that sentence, there's the phrase 7 of the 23 companies in, and that needs to be stricken.
And with that correction, if I were to ask you the same questions today that are in your testimonies, would your answers be the same or similar?
Yes, they would.
At this time, Your Honor, I would ask to move into the record Pepco Exhibits 25 and 26.
Hearing no objection, Pepco's exhibits 25 and 26 are moved into evidence.
In addition, Your Honor, the witness has prepared brief live rejoinder.
He may.
Thank you. Mr. McKenzie, did you read the surrebuttal testimony of staff witness McAuliffe, specifically page 12, regarding whether he agrees with your opinion that the Exelon separation will not have an impact on the company's ROE in this proceeding?
Yes, I did. And Mr. McAuliffe states he agrees that the separation won't impact Pepco's ROE in this case. He does go on, however, to state on that same page 12 that the impacts of the separation are not yet known at this time. And he states, I disagree that this separation will not have an impact in the future. And he argues that by spinning off the generation operations from Exelon could become less risky, and that this could lead Pepco's credit ratings to increase, which would suggest a lower cost of equity in his view. And he also suggests that the separation might negatively impact Maryland ratepayers because it might, in his words, require Pepco to raise equity rather than relying on the parent company, which might cause Pepco to request a flotation cost adjustment. And he also suggests that the separation might impact the stock price in a way that increases Pepco's ROE. And his ultimate conclusion is that at this time, it can't be concluded that there will be no impact on Pepco's ROE in the future.
Thank you. And do you agree with staff witness McAuliffe's statements?
Well, I certainly agree with his conclusion that the ROE in this case is not impacted by the separation. That's consistent with my testimony. But I don't agree with his other points. I think first off, as Mr. McGowan discusses in his testimony, following the acquisition in 2016, this commission instituted what I believe he referred to as platinum standard ring fencing provisions. So that the entire point of those ring fencing provisions is to insulate Pepco from risks of Exelon's other operations. So to ensure that Pepco is treated separately and independently, and that's been the effect of those measures. So with Pepco insulated from Exelon and those subsidiaries, there's no real basis to conclude that the separation is going to have an impact on Pepco's credit standing. Their ratings are already insulated from any of those impacts. And after the separation announcement, S&P and Moody's have both continued to maintain a stable outlook on the ratings for Pepco, BG&E, and Delmarva. So there's no evidence that there's going to be a change to the utility's credit ratings as a result of the separation. And Fitch also has affirmed the ratings for all of the regulated subsidiaries. So as to the stock price issue, I think the important part to recognize here is that we're not looking at Exelon when we estimate the cost of equity. We're looking at a proxy group. And in fact, Mr. McAuliffe's proxy group doesn't include Exelon, nor does mine. So to the extent that the stock price for Exelon moves in one direction or another after the separation, that doesn't really have any implications for the analyses that are typically used to estimate the cost of equity. So I don't think that point has any relevance to Pepco's ROE going forward. And finally, in terms of the flotation cost issue, I mean, the only way Pepco gets equity is by retaining earnings in the company as opposed to paying them upstream as dividends to the parent, or through equity infusions from Exelon. It doesn't raise common stock, so there is no flotation cost issue with respect to Pepco directly. So, I think flotation costs are a legitimate consideration. I haven't included them in my analysis because of deference to the Commission's prior rulings on that issue. But there's nothing specific to flotation costs that are related to the separation that would raise this as an issue in the future, in my view.
Thank you. And in his surrebuttal testimony, staff witness Mr. McAuliffe also suggests that there is a contradiction between your previous testimony supporting an upward adjustment due to attrition and your testimony here. Can you please respond to his position on this?
Yeah, there's no contradiction. I mean, Mr. McAuliffe is correct that in case number 9406, which was a BG&E case, I did recommend that the Commission consider an upward adjustment to the ROE to recognize the impact of attrition, because at that time BG&E had been chronically unable to earn its allowed ROE, which is a violation of regulatory standards. And what we're trying to do is ensure at least the opportunity to earn that ROE. And one way to do that would be through an upward adjustment to the ROE itself. Another way would be through regulatory mechanisms. And I think the MYP is an example of one of those. Here in this case, Pepco also has experienced historically attrition problems and an inability to earn its ROE, and the credit ratings have pointed that out. But again, the MYP is a way of addressing that. I'm not suggesting an upward movement in the cost of equity here. But again, I think the important point is that the MYP is putting Pepco on an equal footing with other companies in the industry and giving the utility, hopefully, an opportunity to earn its allowed ROE going forward. The other companies in the proxy groups also operate under a wide variety of regulatory mechanisms that are designed to achieve that objective, including 7 of the proxy companies that have operating utilities that operate under MYPs. So there's no basis to distinguish between Pepco and the group on the basis of the MYP in this case, in my view. And I don't believe there's any contradiction between my earlier testimony that based on the circumstances in that BG&E case, an upward adjustment to the ROE would have been one way to accommodate that under-earning.
Okay. On pages 10 and 11 of his testimony, Mr. McAuliffe takes issue with your characterization of Federal Reserve policies as placing artificial downward pressure on interest rates. How do you respond?
First, I want to clarify that I certainly agree that capital costs are linked. So equity costs and interest rates generally move in the same direction. And Treasury bond yields are a very important benchmark that investors refer to when they're estimating capital costs or evaluating opportunities in the market. That said, my testimony really goes to the distinction between normal markets and kind of what we've experienced since March last year. And in times of turmoil, Treasury yields can get wonky in terms of equity costs. So if investors are seeking safety, they will move into Treasury bond yields, into Treasury bonds, which drives prices higher and lowers the yields. But that same risk circumstance that made them do that actually suggests higher cost of equity for common stocks. So there are periods of time when the movement in Treasury yields doesn't necessarily track common stocks. And the other important point is the Federal Reserve's intervention in the markets. And this isn't artificial in the sense that it's not actually happening, or it may not be ongoing. I mean, I think what it is a presence in the market that is abnormal. It is not the operation of buyers and sellers in the market. It is the Fed stepping in and buying up huge quantities of bonds in an effort to actually put pressure on those yields downward. the amount of bond buying is extraordinary. It's equal to the GDP of Japan and Germany combined. And they're also buying corporate bonds. So the same thing applies there, including utility bonds. They're not buying common stocks. So there's no support program for equities, for utility equities or for anybody else. And I think that's the distinction. We just need to be careful about associating a drop in treasury yields during a period of turmoil with the true direction of the cost of equity. And I think even Dr. Woolridge, recognizes that in his testimony. He shows a widening spread between allowed ROEs and treasury bond yields. And I think that's significant in the fact that regulators are understanding that relationship.
Thank you. Staying in Mr. McAuliffe's rebuttal testimony, specifically pages 10 and 11, he argues that you are contradicting yourself on the issue of treasury bond yields and their relevance. What is your response?
Yeah, I addressed most of that in my last answer, but again, I think that treasury bond yields are a factor that investors consider, and certainly the movement is indicative in general terms of the movement in cost of equity. But there are certain circumstances that we have to be very mindful that those relationships can be disturbed. I think, in the regards to bond yields, if we look at what's been happening more recently in the bond markets, interest rates have been moving up, not staying flat or declining as the other witnesses in this case are suggesting. And since the Commission's decisions in the Delmarva and BG&E cases last year, 30-year Treasury bond yields have increased about 70 to 100 basis points. So under Mr. McAuliffe's own logic, this supports an upward move from the 9.6 and 9.5 ROEs approved in those cases, especially when we consider that Pepco's Moody's credit rating is a notch weaker than BG&E's.
Thank you. Also in his rebuttal testimony, pages 16 through 18, Mr. McAuliffe continues to argue that current beta values are somehow distorted. Is this justified?
No, not in my view. I think it's very important to recognize that the beta values that we observe are a reflection of investor sentiment and their actions in the market in response to actual events. And there's no indication that there couldn't be another actual event just like the one we experienced in March. Mr. McAuliffe is suggesting that this should be watered down or removed. But in my view, that really goes against the entire notion of the CAPM, which is really based on the relative movements of the utilities stocks relative to the market. And that is reflected in the actual data. There's no argument that Value Line is not using a best practices approach when it calculates beta. Mr. McAuliffe is just suggesting that the actual events over this last year should be ignored. And I don't believe that's appropriate. And I think, if we go back to before the financial crisis in 2008 and 2009, utility betas were as high or maybe a little higher than they are now. And in response to that crisis, utility betas fell significantly. And there weren't arguments at that time that we should ignore the fall in utility betas because the financial crisis was a one-off event. And I think the same is true now. I think that the Commission should base its evaluation of CAPM results on objective data, not on speculation about what investors might consider to be typical or atypical.
And one last question for you, Mr. McKenzie. In his rebuttal testimony on page 4, Dr. Woolridge states that you dispute RRA data showing lower allowed ROEs for distribution utilities. Is this a correct statement?
No, it's not. I don't dispute that. That's a factual issue, and I don't take issue with it in my testimony whatsoever. I do make the point that whether or not a company owns generation assets is just one feature that investors would consider in analyzing the overall investment risks of the company. And those overall investment risks are expressed in objective measures like credit ratings and other measures like published value line risk indicators. Pepco's risk measures are comparable to the companies in the Proxy group. Their credit ratings are identical to the average for the Proxy group. So there's no basis to imply that Pepco should receive a lower ROE on that basis. And I'd also point out that BG&E and Delmarva are also distribution utilities. And given the recent trends in interest rates that I just discussed, I think currently that Pepco should be justified an ROE that's higher than 9.5 or 9.6 on that basis.
Thank you, Mr. McKenzie. And Your Honor, the witness is available for cross-examination.
We'll begin the examination by counsel for Office of People's Counsel. Mr. Alexander, you're on mute.
Oh, thank you, Your Honor. Let's start again. Mr. McKenzie, I'm Gary L. Alexander. On behalf of the Maryland Office of People's Counsel, we are 4 minutes before the afternoon, so I will wish you a good afternoon. I want to just start for a second with some of the questions that you were asked on Rejoinder. You discussed the merger between Exelon and the PHI companies. And you also discussed the spinoff that is supposed to occur in 2022 between Exelon and some of its regulated utilities. Is that correct? You discussed that?
Yes.
God. Excuse me, Your Honor, I gotta, okay. Can you tell me the main reasons for the merger between Exelon and the PHI companies?
Objection, Your Honor. Mr. McKenzie is not a Pepco witness, a company witness, such that he does not know the details of that information.
Sustained.
Well, okay. Do you know the reasons for the spinoff coming in 2022? Since you discussed those.
No, I don't discuss the reasons for the spinoff. I just discussed my opinion that the spinoff won't affect the risks of Pepco.
So the reasons, so in your testimony, the reasons for the spinoff don't matter to investors.
No, I didn't testify to that. They don't matter with respect to the ROE for Pepco in this case. That's my testimony.
Okay, Mr. McKenzie, if you'd go to your direct at page 3, lines 1 through 5. Tell me when you're there, please.
I'm there.
Okay, I've got to adjust my volume again. I'm sorry. There we go. Let's try that. When the sentence that starts, I recommend, you recommend, you say, a cost of equity range for the company's electric operations of 9.5% to 10.8%, correct?
Yes.
Okay, now, wouldn't that mean, and this is, am I correct in stating that this is your range of reasonableness?
Yes.
So if the commission ordered a 10 point, well, let me ask you this. You are familiar, you testify to the the requisites of the Supreme Court cases of Hope and Bluefield, correct?
Yes.
Okay, so would 10.8% fall within those guidelines or requisites of Blue and Hopefield?
Well, in my view, obviously 10.8% is the very top end of my range. That's not the ROE I'm recommending, but I think that falls within the range of reasonableness for the cost of equity that investors require based on the analyses in my testimony. Now,
So
implementing.
it would satisfy, I'm sorry. So it would satisfy, Blue and Hopefield. Is that correct? Yes or no, please?
Yes, it would satisfy Hope and Bluefield, but I think again, just like an ROE at the low end would be
well, I haven't asked
less
you about that
favorable.
yet. Mr. If you could answer the questions asked, I'd appreciate it. We'll get through this much quickly because I'm about to ask you about the 9.5%. If you wouldn't, does that satisfy, in this case, the requisites of the Supreme Court cases of Hope and Bluefield?
Again, I would suggest that it would. It's not the ROE I'm recommending, but it would satisfy those requirements.
Okay, and we'll go to what you're recommending, which is the next sentence, that you are concluding that 10.2% midpoint of this range represents a just and reasonable cost of equity. Is that correct?
Yes.
Okay, and again, to just make sure I cover all your bases, I am assuming that 10.2% satisfies the requisites of Hope and Bluefield, correct?
Yes.
Okay, if you would go to your direct at page 5, and that would be at lines, I think 14 to 24. It's the question that states, how do you identify the proxy group of electric utilities relied on for your analyses? Are you with me there?
Yes.
Okay, good. And you say, just 2 lines later, you begin with the following criteria to identify a proxy group of utilities, correct?
Yes.
Okay, and there are 5 criteria which you identify as the beginning of your analyses, correct?
Yes.
Okay, and if we go to number 3, it says that you will not include a company in the proxy group that is involved in a major merger or acquisition that would distort quantitative results, correct?
Yes, I do.
Thank you. So now if you would go to your Schedule AMM, Alex Mary Mary -4, page 3 of 4, and just tell me when you get there, please.
I'm there.
Okay, so the 4th one down of the companies, it's Alliant, Ameren, American Electric Power, and Avangrid, AVANGRID Inc. is the 4th one, correct?
Yes.
Okay, and can you state in brief what the last column, the small non-large cap BR plus SV means? Why is it in the last column?
Well, it's just distinguished from the other cost of equity estimates that are based on analyst growth estimates for earnings. As I discuss in my testimony, this growth measure is based on a combination of earnings retention and expected earned returns on book value.
That's great. And does the blue mean that you are excluding for Avangrid, in the last column, the 5.5% from your calculations?
Yes.
Okay, and just to flesh it out, you're excluding the blue for Consolidated Edison under Zacks 6.2, correct?
Yes,
And you're excluding the 6.3 from Dominion Energy under IBE. That's for the reporter. I, B as in boy, E as in Edward.
and S is in Sam. Yes.
Oh, yeah. Thank you. I appreciate that. I missed the S for Zax too. So now I'll get that in. Thank you, Mr. McKenzie. Okay. So in your if you turn to your rebuttal, and I'll let you do that at pages 57 through 58. And if you'll give me 1 second, I want to turn off my phone. Okay. Are you there?
I am.
Okay. And your question is, what proxy groups does Professor Woolridge use as the basis for his quantitative analysis? And you state that he uses 2 groups, and you state it's not the same group of the 23 companies that you rely on, because Professor Woolridge subtracts Avangrid, and according to you, doesn't offer any explanation, but you include it. And so when when Avangrid is excluded from the proxy group, what is you say Professor Woolridge has titled McKenzie Proxy Group is not your proxy group, correct?
Yes, that's correct. I mean,
Okay.
Sorry, go ahead.
Well, I'm going to your next question. So if you keep going down, why should Avangrid remain in the proxy group? And you give a number of reasons with the S&P ratings, the safety rank, financial strength, and you qualify that by saying it may not have a value line safety rank. You still believe that it's close to Exelon. And these ratings together indicate that Avangrid and Pepco are of comparable risk. And that's the term that is used for one of the requisites of Hope and Bluefield, correct?
Yes.
Okay. So now, do you have available to you Dr. Woolridge's surrebuttal testimony?
I do.
Good, thank you. And you've reviewed that surrebuttal testimony, correct?
Yes, I have.
Good. So if you would go to page 12 of the surrebuttal, lines 9 through 21. Would you agree that Professor Woolridge discusses your objection to his exclusion of Avangrid from, I guess, his proxy group instead of your?
Yes, I do. And in fact, I agree with Dr. Woolridge on this point. If I had been doing my analysis prior to the announcement of this merger, I would have excluded Avangrid on that basis too.
And that's what he says. You were right when you did it, but then he was right because the merger announcement became in between, right?
Yes, that's correct.
Okay, thank you. And can I get you to turn back to your direct at pages 57 to 58? And that would start off with your question throughout your testimony. You refer repeatedly to the concepts of financial strength, financial integrity, and financial flexibility. And are you with me on that question?
Sorry, I was in my rebuttal.
That's okay. Nope, that's okay. Don't worry about it. I sometimes jump the gun. So it's your direct at pages.
I'm here.
Good. So you state that these terms are generally synonymous, and that this is what you mean you need to comply with the Hope and Bluefield Supreme Court standards, right?
Yes, these are one aspect of what's required by those standards.
Yes. Oh, I'm sorry. I did. Yes, one aspect. Absolutely. And you say that the company must generate adequate cash flow from operations to fund these requirements and for repayment of maturing debt, together with access to capital from external sources under reasonable terms on a sustainable basis, correct?
Yes.
Okay. Now, when you say together with access to capital from external sources, is one of those sources investors who buy Pepco's debt issuances?
Yes.
Okay. Do you know if, well, I'll say it this way. Isn't it true that Pepco's access to these investors for the issuance of its debt has not been impaired or is not impaired at present?
No, it is not. Pepco has solid investment grade credit ratings.
Okay, and then you go on to state that ratings energy, oh no, I'm sorry, strike that. Rating agencies and potential debt investors tend to place significant emphasis on maintaining strong financial metrics and credit ratings that support access to debt capital markets under reasonable terms, correct?
Yes.
Okay, right now, before I'm going to go on, but is there anything at present that would indicate that Pepco does not have access to debt capital markets under reasonable terms?
No.
Okay, thank you. And you say that this emphasis on financial metrics and credit ratings is shared by equity investors who also focus on cash flows, capital structure, and liquidity, much like debt investors. Right now, does Pepco have any problems with its cash flow in this context of what you're saying?
Not that I'm aware of, no.
Okay, and the proposed capital structure, which Professor Woolridge, and I think everybody has accepted, is, I think, 50-50 or 49.550. Do you know what the proposed capital structure is? Because it was the other witness who
I recall 50.5% common equity.
Okay, so it's roughly half and half.
Yes.
And liquidity, is there any problems with Pepco's liquidity at present?
No.
Okay, now you say that then following, same place, that investors understand the important role that a supportive regulatory environment plays in establishing a sound financial profile that will permit the utility access to debt and equity capital markets on reasonable terms in both favorable financial markets and during times of potential disruption and crisis. Did I read that correctly, please?
Yes.
Okay, so is that supportive regulatory environment, does that include the results of this case 9655 Pepco MYP?
Yes.
Okay, now the next question, what part does regulation play in ensuring that Pepco has access to capital under reasonable terms and on a sustainable basis? And you talk again that regulatory signals are important for investors, and security analysis, they study commission orders, including presumably the one that will come out of this case. And then in line 24, you state, as Moody's noted, the regulatory environment is the most important driver of our outlook because it sets the pace for cost recovery. Do you still affirm that your statement there?
Well, it's Moody's statement, but I affirm they made it.
Yes, okay. And do you agree with it?
Yes, I do.
And then the next sentence is, similarly, S&P observed that regulatory advantage is the most heavily weighted factor when S&P Global Ratings analyze a regulated utilities business risk profile. I know S&P said that. I presume it's there because you agree with that statement. Is that correct?
Right. Well, more importantly, I guess whether I disagree or agree with it is the fact that because the credit rating agencies are saying this, they're informing investors of the importance of the regulatory environment. So that's the reason why I'm quoting this, not as my opinion, but as an indication as to what investors consider to be important.
Fair enough.
Mr.
Now,
Alexander,
yes,
can I, sorry for the interruption. Can you give me a sense of how much cross-examination you have for this witness?
let me flip down the pages.
The reason I ask is because we're coming up against a break, and since we started a little late today, we also have lunch scheduled.
Well, you know, Your Honor, from prior cases, I always support lunch. It's not going to be 5 minutes. And the reason why I'm hesitating, Mr. Chairman, is because I know from myself and all of the commissioners' experience that a lawyer will say, oh, I've just got a few more and it'll take about 10 minutes. And then it turns out that it's 45 minutes. And that is a common thing to happen. And I don't want to tell you that it will only be 10 minutes, but then take 45. That's why I hesitated. I'm fine in breaking if the chairman would like, because it's going to be more than 10 minutes, I think.
Okay. All right. With that, let's split your cross into two distinct halves. But if there's a natural break point, if you want to finish this line of questioning, and then you could.
Yes, I'm going to check that, Your Honor. Uh-oh. There it is. If you'll hang on 1 second, please. All right, I'll finish this part, Your Honor. This will be short.
Okay, so we'll take a lunch after you finish these questions.
Yes, it is short. Now, Mr. McKenzie, and thank you for your patience. When we go to S&P's observation, it says regulatory advantage is the most heavily weighted factor, et cetera, et cetera. What in your mind, I know it's S&P's statement, but since you included in there, what in your mind is, what does S&P mean by advantage, regulatory advantage?
Well, in my mind, that would be just the relative treatment that's afforded to the utility by the regulator. So the extent to which the company is treated fairly in the regulatory environment, the extent to which it's been able to have an opportunity to earn its fair rate of return and to have sufficient cash flows to support strong credit metrics.
Now, if the commission were to find that out of this case, they will award a return on equity to Pepco of 9.5%, would that be disadvantageous to Pepco in your mind? In terms
Yes,
of what S&P is saying?
well,
Sorry, go ahead.
In my mind, it certainly would be disadvantageous to the equity holders in Pepco because it's below the midpoint of my range. As we discussed earlier, it is at the bottom of the range, so I wouldn't classify it as failing to meet the Hope and Bluefield standards, but obviously it's at the very bottom.
Okay. And again, focusing on regulatory advantage. If say the commission awarded your recommendation of a 10.2% ROE, and that would be a regulatory advantage, would that mean that ratepayers would be at a regulatory disadvantage?
Well, I certainly recognize, obviously, the commission's prerogative is to balance the needs of ratepayers, the interests of ratepayers, the interests of equity holders. In my view, based on my analyses, the 10.2% is representative of the cost of equity. So in my view, that doesn't disadvantage or advantage anybody.
Okay, and thank you. Do you, wait, let me just see before I move. Your next statement in that same paragraph is a summary by value line of these sentiments expressed by Moody's and S&P. And value line says, as we often point out, the most important factor in any utility success, whether it provides electricity, gas, or water, is the regulatory climate in which it operates. Harsh regulatory conditions can make it nearly impossible for the best run utilities to earn a reasonable return on their investment. In your mind, now I know this is value line statement, but I'm presuming you're stating it because you agree with it. What do you think value lines means by harsh, the word harsh as adjective regulatory conditions?
In my view, I mean, there's a range on the spectrum of what harsh is. Harsh could mean disallowing expenses that might be considered to be prudent. It could mean an ROE that's well below industry averages or below the cost of equity. It could mean failure to keep pace with the rest of the industry in terms of regulatory mechanisms that allow the company a better opportunity to earn its allowed ROE. So there's any number of possible definitions of what harsh could mean. If you look at California, an inability to recover certain costs can put a utility into bankruptcy. So that's obviously at the very extreme end of what harsh treatment can do.
Okay, thank you. Well, let me go to this. Before we go back to this, do you happen to have Ms. O'Donnell's direct testimony available to you?
I do not.
Okay. I hope you can trust me if I read it. For counsel and the commission, it's on page 3 of Ms. O'Donnell's direct at lines 4 through 10. Can I assume that you did read it though?
At some point during the pendency of this case, I've read it, but it's been quite some time.
Yes, and that's why I'm going to state what she said. She's the witness on the capital structure, which again, I don't believe anybody is contesting, although Professor Woolridge believes that it's relatively equity heavy, but that's not what I'm asking. Is the capital structure consistent with the company's goals and objectives regarding capital structure? And she answered yes, the 50-50 is consistent to maintain the company's credit ratings and a target equity ratio of at least 50%. Now it's the next sentence that I'm focusing on. In addition, the company's current credit ratings are based on its commitment to the rating agencies to maintain a minimal capital structure consistent with these percentages. Now, I know you're not saying this, Ms. O'Donnell said it, but do you have an understanding of what Ms. O'Donnell meant by the company's credit ratings are based on the company's commitment to the rating agencies? It's the word commitment that could you tell me what that commitment is in your view, if you agree with Ms. O'Donnell?
Well, I'm not going to speculate as to what Ms. O'Donnell meant when she said the word commitment, but I can give you my view. Basically, the company engages with the credit rating agencies on a regular basis and communicates with them in supporting the ratings process. So there's a back and forth between the analysts at S&P and Moody's and Fitch and personnel at the company. And obviously one of the areas of interest for the rating agencies would be the plans with respect to capital structure and how the company intends to finance capital expenditures going forward. So I think on that basis, Ms. O'Donnell is probably suggesting that Pepco communicated its plans to maintain an equity ratio in the neighborhood of what's being requested in this case going forward. And upon that basis, the credit rating agencies are conducting their analyses and evaluating the company's risks.
So the company, and again, I'm going on your interpretation, not Ms. O'Donnell's. As far as you know, does Pepco go to the credit rating agencies and say, we're going to ask for a 50-50 and we promise you we're going to ask the commission for a 50-50 capital structure? If you know.
Yeah, I don't know. I'm not privy to any discussions between the company's management and analysts at S&P. I mean, I know that aside from what Ms. O'Donnell said, there's also restrictions, I believe, on Pepco's capital structure that are imposed by the ring fencing. So there are constraints on the capital structure that the company can maintain.
Okay, Mr. McKenzie, as Mr. Alexander stated earlier, please just answer the question being asked of you and no need to elaborate beyond that. Mr. Alexander, how about we take our recess now?
We can take our recess now, Your Honor. Not a problem.
We'll do that. We will have our lunch break. We will reconvene at 1:15 p.m. Eastern. Thank you. We are in recess until 1:15.
Thank you.
We'll go back on the record in less than 1 minute. All right, I hope everybody had a good lunch. We will go back on the record at this time. And Mr. Alexander, are you prepared to proceed? Oh, Mr. Alexander, you're still on mute. There you go.
Okay.
All right. Now, Mr. Alexander, before we begin with you, approximately how much more cross do you have remaining? I'm not going to hold you to a precise minute, but 30 minutes?
I would
40?
say, believe it or not, 20 minutes.
Okay, please proceed.
Thank you. Okay, Mr. McKenzie, we were talking about, we were on pages 57 to 58 on your direct.
Yes.
Okay, and you, I'm not, I think it may be lines 6 to 8 on the second page. Harsh regulatory conditions can make it nearly impossible for the best run utilities to earn a reasonable return on their investment. And that is a quote from Value Line. Is that correct?
Yes.
And you have a footnote there, and it's Value Line Investment Survey, Water Utility Industry, published the year 2017, correct?
Yes.
Okay, now, and Value Line is one of a number of trusted financial sources for investors and for these purposes of determining a return on equity for a regulated utility, correct?
Yes.
Okay, now I looked and found from 2013 in Value Line, a survey of American Waterworks Company. And I'd like to know, I'm going to read you a few sentences and you tell me if you agree with them or not. And if you half agree and half don't agree, you're welcome to say so. I'm not trying to pin it. The sentence, so it's 4 sentences, and one of them is, and these are all for American Waters operations are regulated 89% of total revenues. And I'm not asking a question yet. Thus, the company cannot unilaterally choose to raise prices. It must file a rate case in the state involved. Each state has its own regulatory commission. Now it's the next sentence. Thus, to some degree, American Water, like all utilities, operates at the mercy of the state regulatory commissions. Do you agree that for Pepco, and I'm using the language here, would you agree with that language that Pepco operates at the mercy of the Maryland Public Service Commission?
Well, it's flowery language, but I think it indicates that investors recognize that the commission's decisions have important impacts for the financial integrity of the utilities that they regulate. So obviously there's also judicial review of regulatory decisions. So to the extent that a utility feels it's been treated unfairly, it can appeal those decisions. But I think what Value Line is telling investors is that to a great extent, utilities are dependent on the treatment that they get from the regulator.
Okay, and the next sentence is each state has its own regulatory climate when it comes to dealing with utilities. And I'd assume that you'd agree with that, correct?
Yes.
Okay, now this sentence I'd like to know if you agree with. And there is also no law that says regulators must be fair to utilities. Do you agree with that? Would you like me to read it again?
No, you don't need to read it again. I mean, I'm not a lawyer, so I wouldn't be willing to give a legal opinion, but in my view, as a regulatory financial analyst, my understanding is there are, again, judicial standards of fairness that apply to regulators as well as utilities. So again, going back to my earlier comment that regulatory decisions can be appealed, I think if the regulator acts in a way that contravenes the underlying law, then those decisions can be overturned.
So, and I should have actually limited it. Would you agree that the standards that the commission and every utility commission in the US has to abide by the standards of Hope and Bluefield? Would you agree that, and I'm not asking you as a lawyer, but you are familiar with those standards. Do you agree that abiding by, if the Maryland Commission abides by those standards, then they must be fair to Pepco?
Yes, sir. If they meet those standards, then at least by the legal definition of what's fair, they would be considered to be so.
Okay, and then finally, the last sentence that oh, well, let me give you this. It's an article. It's from the survey, American Waterworks Company, Inc., James Flood, June 29, 2013. And it's on Value Line, just in case you want to check it later. I just want to make sure that you or your counsel can do that.
Mr. Alexander, could I ask, I'm not trying to object, but do you have an exhibit that you could showcase to the witness?
No, I didn't, because I didn't, because it's one paragraph. That's it. It was 4 sentences. So I don't, but that's why I can send you the link. If you'd like me to do it, I could send it to everybody, although not right this second, but I can send you the link.
I don't think it'll be helpful later, but thank you.
Okay, I'm sorry. Indeed, and this is the last part. Indeed, until a politician is elected on the platform of, quote, let's raise water rates sky high to be fair to American water, end quote, the utility will always be susceptible to a harsh regulatory ruling because of one simple fact. Politicians who select the member of the regulatory commission know that voters don't like paying high water bills, even when higher rates are justified. Again, you're not saying this. It's Value Line. Do you agree with that?
Objection. I'm going to the relevance. You're quoting something regarding the water utilities, and I don't think that's relevant, and that's not really consistent with his testimony on page 58.
Well, Your Honor, may I respond or not?
No, please don't. We'll move on to your next question.
Okay, thank you. Okay, now I'm going to ask you to go to your electric group ROE results at page 26 of your surrebuttal, I hope.
Well, I don't have surrebuttal testimony, sir.
Oh, I'm sorry. I said it wrong. Hold on, please. Let me get that right for you. It would be rebuttal. It's table R5. And let's see if I got the page right.
You did. I'm there.
Okay, so you have here the average, median, and midpoint of the 5 methodologies you used in determining your recommendation of a 10.2% ROE for Pepco. Is that fair to state?
Yes,
Okay, so, and in there, well, let me do it this way. You have average, median, and midpoint, correct?
yes.
And the average, is the average taking all of the results and then divided by the number of the results?
It's taking the average for each method and then dividing by the number.
Okay,
Yes.
and the median is the median takes all, why don't you say what the median is, please?
Well, under the median column, I've presented the median results for each of the analyses I've conducted. And then I've averaged the medians. So for example, in the CAP-M, the median of one analysis is 10.1 and the median of the second is 10.2, and the average of those two results is 10.2. So the 10.1 that's at the bottom, consistent with the 10.2 in the column to the left, is the average of the medians for each method.
Oh, yeah, I'm sorry, but thank you, because that just went ahead, but that's good. Can you tell me what the median, what a median is?
It's the middle number in a distribution of results. So if we have 5 results, it would be the number that has 2 above and 2 below.
Okay, and it uses all of the data points.
Well, it uses them only in a non-parametric sense. It doesn't consider the numbers explicitly, only by rank order.
Yes, okay, so I didn't say it correctly, so let me see if I could say it correctly. If there are 7 data points, you take the number 4 data point, which is 3 from the beginning and 3 from the ending, and you ignore the substance of the other data points. The only substantive number is number 4, the one in between 3 in the top and 3 in the bottom. Is that right?
Yes.
Okay. And is it correct for me to say that the midpoint takes only 2 data points to arrive at a midpoint? And if I'm wrong, please correct me.
No, that's correct, Mr. Alexander. It's the average of the highest and the lowest.
Okay. And okay. And you were asked questions about Mr. McAuliffe's testimony by your counsel in your rejoinder, correct?
Yes.
And so if I recall, just to make sure that you have reviewed his Mr. McAuliffe's testimony, correct?
I have.
And his recommendation for electricity operations, which is at page 4, lines 4 to 8 of his direct, but I don't think you need to go there, is 9.4%. Is that correct?
Yes.
Okay. And based on your analyses that your range of reasonableness that we discussed a bit earlier, 9.4% based on your analyses would not satisfy the Bluefield and Hope Supreme Court tests.
That's correct. It falls outside my range.
Okay, thank you. And one of your methods in that table R5 is the empirical CAP-M method, correct?
Yes.
And for the court reporter, CAP-M is capital C, capital A, capital P, capital M, and it is for, and correct me if I'm wrong, Mr. McKenzie, the capital asset pricing model.
That's correct.
So it's the E-CAP-M. Now, you've read Well, let me take you there. Do you have Mr. Woolridge's, Professor Woolridge's testimony direct available to you?
I do.
Okay, so if you would, could you go to page 77 of his direct, lines 11 through 19, and I'll wait till you get there.
I'm there.
Okay, and in his Q&A, he says that the commission has considered and rejected the validity of the ECAPM methodology because the commission found that the ECAPM results should be given little weight. As staff witness Vanda Hayden observed, the ECAPM is not widely accepted by the financial community in determining ROEs. And then they quote PULJ in the case below that the ECAPM is rarely, if ever, cited in professional literature. And commission witnesses have generally not used it as a primary method. Would you agree that I basically read this correctly?
Yes, I disagree with it, but you read it correctly.
Well, that's what I'm gonna, you're jumping ahead, but that's where we're gonna go. Okay, so let me just ask you this to set a basis. Since you've read Mr. Woolridge's, Professor Woolridge's direct, and thus you read this Q&A, let me just ask you, did you go and read order number 89072 after you read this in Professor Woolridge's testimony, or at any other time?
I didn't read it after I read Dr. Woolridge's testimony. I'm pretty sure I've read it in the past, but I can't recall specifically.
I'm not going to ask you anything more than in Professor Woolridge's answer to his own question. And so you said that you disagree with it, correct?
Yes.
Okay, now what I'd like to know is, do you disagree, because it's a little compacted in there and I want to unpack it. Do you disagree with what the commission found or what staff witness Vanda Hayden concluded or what the public, you know what? I'm going to break that down. I don't like compound questions. Do you agree that in this case, the ECAPM, our commission found that the ECAPM results should be given little weight? I'm going to ask you two questions about that. Do you agree that the commission found that?
Well, I haven't.
I'm going to ask you a second question. So,
right, I haven't reviewed the order, but I'm certainly not contesting that. I'm not suggesting that Dr. Woolridge has misquoted the order. So I think we
okay, thank you. So let's go on to the next one. Staff witness Philip Vanda Hayden observed that the ECAPM is not widely accepted by the financial community in determining ROEs. Now, do you disagree with Mr. Vanda Hayden's observation?
Yes, I do.
Okay, and I'd like to give you a minute, not a lot, but a minute or two to explain why you disagree with Mr. Vanda Hayden's observations.
Well, I addressed this in my direct testimony in support of the CAPM, I believe, and in my rebuttal. The ECAPM has been used by the financial community in determining ROEs. It's been used by the staff at the Maryland Commission. It's been adopted by regulatory agencies, including the Regulatory Commission in Alaska. More recently, the Montana Commission concluded that it was a superior method for determining the ROE and that they were going to rely primarily on the ECAPM for that purpose going forward. It's used routinely by the New York Public Service Commission in establishing ROEs in that state. And it's been used by staff witnesses and intervener witnesses in a variety of proceedings. So I don't agree that it's not widely accepted on that basis.
Okay. proposed order of the PULJ observed that the ECAPN is rarely, if ever, cited in professional literature. Now, did you, in either your direct or your rebuttal testimony, have you provided cites about the ECAPM in professional, I assume, finance or economic literature where it is favorably cited? Is that in your testimony somewhere?
Indirectly, it is. I mean, I cite to Dr. Roger Morin's book, Regulatory Finance, as support for the particular form of the ECAPM model that I apply in my testimony. And Dr. Morin's book provides numerous citations to the literature with respect to the research that supports the ECAPM equation presented in that treatise.
Okay, didn't Dr. Morin, didn't he create the ECAPM?
I don't know that I would say that he created it. I think it's basically he has a certain set of weights with respect to the market beta and the company specific beta that he feels is justified for utilities based on the research. But the research with respect to the difference in the slope between what's predicted by the CAPM and what's observed is based on financial research, not on any whim of Dr. Morin.
Okay, so thank you. So does Value Line use the ECAPM?
Well, Value Line doesn't use any models with respect to calculating investors' required rate of return. So they don't present any analysis using a CAPM or a DCF model or an ECAPM.
How about IBES?
Again, IBES or IBIS is a service that collects analysts' earnings growth rates. That's their sole objective. So they don't present any analysis whatsoever with respect to an evaluation of the cost of equity.
So it would be analysts, stock market analysts, investment analysts who, if they were using methodologies, then the ECAPM would be something they use, correct?
They might choose to use the ECAPM along with other methods, yes.
Okay, so would you agree that the one method that the analysts use almost across the board is the discounted cash flow or DCF model?
The DCF model, yes, is certainly a common methodology that's cited.
And would you agree that another method pretty much across the board that investment analysts use is the CAPM method?
Yes.
Okay, now, do you know of any analyst reports where they also use, in addition to those two methods, or in addition to the CAPM, an ECAPM?
I'm not aware of any specific reports. I know that S&P in their RRA publication recently talked about methodologies that are commonly used to estimate the cost of equity, and they mentioned the ECAPM along with the expected earnings approach or comparable earnings approach.
Thank you. Well, let me see this. If you go to your rebuttal at pages 24 to 25, and let me just make sure I've got that right, because I combined the two. So I said 24 to 25, and I said,
Mr. Alexander, as you're looking for that,
Yes.
you did promise me about 20 minutes and we're at about 25 now. Do you have a revised estimate?
No, I'm rounding home, Your Honor. Well,
Thank you.
I got a few more, but I should be able to just get them out really quickly. I just want to make sure that I've got the correct pages, 24, 25 of your rebuttal. And let's see if I can make sure I could do that right. Yeah, it is. On 24 to 25, you respond to staff witness McAuliffe about a few different issues. And on line 17, the question is, before responding to staff's methodological shortcomings, staff witness McAuliffe claims that you developed your range by taking the mean of your average and midpoint. And you ask yourself, is this accurate? And you say no. You determine the range based on your professional judgment, giving less weight to the extremes, high, and the low ends of the range. And I want to just focus on that sentence. When you say your professional judgment, giving less weight to the extremes, reading either of your testimonies and the attachments, can I myself find in there where you used your professional judgment?
Well, my judgment is discussed throughout the testimony. I think one example would be, for example, the BR plus SV growth rate. I talk about why I don't believe that's as solid a figure to use as investors' expectations, and that I feel like that should be given less weight in evaluating the DCF results. So there's a presumption there that the earnings per share growth rates are a better measure, and I place greater weight on those. So that would be one example.
All right. Is it consistent? Is your professional judgment consistent across the board, that by looking at all of these data and your conclusions, that I can frame your professional judgment in terms of a system or a formula or something that I can apply across the board that would be your professional judgment?
There's no formula, Mr. Alexander. That's clear. I mean, and that's not uncommon. I mean, Mr. McAuliffe, for example, recommends a range of 889 to 969 and comes up with a recommendation of 94. So that's a number within that range, but there's no mathematical formula to get there. And just as there's no mathematical formula to go from all of the results in my analysis down to the range that I presented.
So you don't have a narrative explanation of what exactly your professional judgment is predicated upon, other than your own doing this a lot.
And the fact that, as I explained, I give less weight to the numbers at the high and the low ends. So in my judgment, I'm looking at the DCF and seeing an ROE of about 9, and I'm looking at the risk premium and seeing about 9.6, and considering those together, I set the lower bound of the range at 9.5. And similarly, the top end is below the highest of my results. But there's not a mathematical formula that gets you there.
Can you go to pages 4? Well, 4, you don't have to go through it. It's pages 4 through 14 of your rebuttal. You assert that Dr. Woolridge's 9.0% ROE does not meet acceptable ROE benchmarks. Is that right?
Yes,
Okay, now one benchmark you used are authorized ROEs for electric utilities. Is that correct?
yes,
Okay, and we've already stated your ROE recommendation is 10.2%, correct?
yes.
Okay, now if you would, to Professor Woolridge's direct testimony on page 26, and I'll give everybody a chance to be there, line 1.
Okay, I'm there.
Okay, and Dr. Woolridge highlights the fact that the average authorized ROE for electric delivery companies was 9.10%. Is that right?
Yes,
Okay, and you'd agree that Pepco is an electric delivery or distribution company, correct?
yes.
Now, for that 9.1% figure, after I read through, you didn't challenge that figure in your rebuttal, correct?
No, I didn't challenge that number.
Okay,
That
so,
number is report.
oh,
Go ahead.
no, you go ahead. I'm sorry, I
No,
interrupted.
I was just going to say that number is reported by RRA, so his reporting is accurate.
Okay, and RRA is again a respected and authoritative source for investors and financial analysts and economists, I guess. Was that right?
Yeah, I mean, I think that's a little broad. It's certainly an accepted source of reported allowed ROEs in the utility industry.
Okay, that's fine. Now, can you, and this is not a yes or no question, can you explain how it is that Dr. Woolridge's ROE recommendation of 9.0% is much closer to 9.10% that we just discussed for the average authorized ROE for electric delivery companies than your ROE recommendation of 10.2%?
Well, I mean, that's just the math. His number is closer. I don't think that makes it more reasonable. I think there's a number of reasons why the commission should not be looking towards the 9.1% benchmark that he cites. I mean, as I discussed in my rejoinder earlier, the extent to which a utility has distribution or generation operations is only one facet of the risk analysis. And if we consider Pepco's risks versus BG&E's, they're slightly higher, and BG&E was awarded an ROE of 9.5. Same is true with Delmarva, a distribution utility that was awarded an ROE of 9.6, and interest rates are higher than they were then. I think if we look at gas company ROEs, they don't own generation assets either, and the commission just awarded a 9.7% ROE to Washington Gas Light. So there's any number of other benchmarks that I think the commission should consider. I think the distribution only results for 2020 are also colored by the fact that interest rates were lower in 2020 than they are now. So I think all of those things are important considerations.
Okay, and you were talking about in your answer, the risks to Pepco. Is one of the things that make a financial result for Pepco and its operations, is one of those factors regulatory lag? That is, that it gets its revenues more closely to, rather than further than when it makes those investments.
Well, I think if we truncate your question a little bit, and if you want to ask me whether I think regulatory lag is a factor that impacts risk, I agree with you, sir.
Okay, well, that would actually, thank you for truncating it, especially as the chairman wants me to wind up. So would you agree that this proceeding in which you're testifying, one of its purposes is, as a 3-year multi-year rate plan, is to decrease the duration of regulatory lag, and therefore would mitigate some of that risk that makes Pepco a riskier investment?
Yes, I'd agree that the multi-year rate plan does address attrition.
Okay, now, did you factor that in your professional judgment to the ROE? And if you did, where can you tell me in which testimony, your direct or rebuttal, you factored that in so that it would make a numerical difference? What I'm saying is, if you had a 10.2, but you looked at it with the decrease in regulatory lag, you would say that and say, but I'm going to recommend 10.1 as a result of the mitigation, in this case, of regulatory lag. Is there somewhere in your testimony where you do that?
No, in fact, my testimony argues that there shouldn't be an adjustment for the MYP based on the fact that the proxy group that we use to estimate the ROE already benefits from any number of regulatory mechanisms that are designed to achieve the same end result. So the fact that Pepco has been unable to earn its authorized return in the past might be corrected by the MYP, hopefully going forward. But there's no indication that approval of the MYP is going to result in a material change to Pepco's investment risks. For example, the credit rating agencies are well aware of the MYP, but they're not putting Pepco on watch for a potential upgrade on that basis.
Okay, would one of the factors of a regulated utility like Pepco, would one of those factors be management, good management?
Yes, management's competence and abilities are considered in that evaluation.
Okay, and are you aware of that? A few years ago, Pepco was fined $1 million by our commission, roughly, for poor maintenance in its assets.
I am not.
Okay, so going back, one other issue, you were saying that the proxy group has companies that also include some of these mitigation factors, like a BSA or something, so that they're already included in the companies in the proxy group, correct?
Yes, that's correct. I think that on balance, the range of regulatory mechanisms that are available to the proxy companies are built into the ROE estimates that we're looking at in the case. And so there's no need to make a downward adjustment for the MYP year.
Okay, and so let me just ask you, are you aware that 2 electric delivery companies in Illinois, Ameren, Illinois, and Commonwealth Edison, in the past month filed rate cases where they have proposed ROEs of 7.36%?
Well, I'm aware that those companies filed with an ROE of 7.36%, but I think it's incorrect to characterize that as their proposal. That's not a result that's based on any notion of capital market requirements. It's based on a legislative formula, which incidentally is up for change because I think folks in Illinois have realized it doesn't produce a reasonable result. I mean, the Illinois Commission, at the same time they approved Ameren's last electric ROE, which I think was about 838, approved an ROE for Ameren's gas utility of 967. So the only reason we're getting that result is because it's a formula that's tied to treasury bond yields. And I've discussed the problems with that in my testimony.
And those yields that the ROE is the average monthly 30-year treasury yield over the past year plus 580 basis points. Is that correct?
Yes.
Okay, so given what you've just said about the Illinois Commission and how it applies rates, wouldn't you say that the Maryland Commission's ROEs are not reflective of a harsh regulatory environment?
That's right. I don't believe they are reflective of a harsh regulatory environment.
Okay. Your Honor, if you give me one more second. Your Honor, I'd have to look another moment or two, and I know you're not rushing me, but that's okay. I think I got the questions I need out. That is the end of my cross-examination. I turn it over to staff with your permission.
Thank you, Mr. Alexander. Mr. Albert, if you are prepared to cross.
Thank you, Chairman. Good afternoon, Mr. McKenzie. I would refer you first to your Schedule AMM-3, which is attached to your direct testimony. Let me know when you're there.
I'm there, sir.
Page 1 of 4. If I'm understanding this correctly, that column on the left, fuel PPA, and if you look the letters D, there are 3 letter Ds as in David. Those indicate that of those 23 companies, 3 of them are distribution-only companies, which means the flip side of that is 20 of the 23 in your proxy group are utilities that own generation. Is that correct?
That's right. That they at least have one or more operating subsidiaries that own just generation. They may also have subsidiaries that don't, such as Duke Energy. Duke Energy Ohio operates, does not have generation, but its other subsidiaries do.
Okay, so this is focusing on the utility itself. There could be obviously a generation affiliate, a merchant, an affiliate that owns merchant generation, but separate and apart from the utility, correct?
No, on pages 2 through 4 of my exhibit, I present the results for the operating utility subsidiaries of the companies in the proxy group. So I was just trying to clarify that that some of those utility subsidiaries may be distribution only, but if the company has another subsidiary that has a fuel and PPA adjustment, I show that in the column on page 1.
Okay, now I'm going to pull up a document, and I would ask for guidance from the chair. This is the Exelon SEC Form 10K for the year 2020. Now, I had circulated this, and this was in the documents. I think it was Friday that staff circulated along with links. I recirculated it last night at 5 o'clock. I can pull that up on my screen, and I don't know if you need me to share it, Chairman.
Mr. Albert, we did receive the email from you through the executive secretary. If you'd like to screen share it, I would ask that the host advisor transfer privileges to counsel. So just wait one moment, Mr. Albert. Okay, you should be ready to share.
Oh, good. Thank you. I'm like, why isn't it working? Okay, bear with me a second here. All right, let me try that again. I'll pull it up. And okay, share. Okay, does everyone see that?
Yes, we do.
Excellent. Now I want to refer first to the bottom of this page 31. where it's specifically, and I'll read that, Ms. McKenzie, generation, the heading goes, generation is exposed to price volatility associated with both the wholesale and retail power markets and the procurement of nuclear and fossil fuel. And it references Exelon and generation. And the next sentence, generation is exposed to commodity price risk for the unhedged portion of its electricity generation supply portfolio. Generation's earnings and cash flows are therefore exposed to variability of spot and forward market prices in the markets in which it operates. And let me just point two other, this you would agree is Exelon in its Form 10K, where they're talking about the risks they face. They're targeting specifically the risks associated with the fact that they own power generation. Is that correct?
Well, it is, but I think it's important to recognize that they're speaking about competitive generation assets, not generation assets that are owned and operated by a regulated utility.
Well, let me go on then to the next page, another. And I'm heading in the middle of the page. Under cost of fuel, generation depends on nuclear fuel and fossil fuels to operate most of its generating facilities. The supply markets for nuclear fuel, natural gas, and oil are subject to price fluctuations, availability restrictions, and counterparty default. Again, doesn't that identify a discrete set of risks associated with power generation?
And again, I would clarify that I believe that what they're discussing is risks associated with competitive power generation. As we discussed earlier, all of the companies in my proxy group that have generation assets, regulated generation assets, benefit from a fuel or a PPA adjustment. So fluctuations in fuel costs are generally not an exposure that regulated utilities face through the ownership of generation assets.
Though under that sentence, it does refer to availability restrictions in referring to fuel for a plant. That's more of an operational thing, which would apply regardless of whether this is a utilities generation or a merchant generation. Is that correct?
It would, but the implications, I think, are much different. I mean, I think if we look at the recent weather event in February where certain generators were unable to run in the central states and in the south due to insufficient gas, for example, that obviously implies an inability for a competitive generator to generate revenues, but it's not the same exposure for a regulated utility.
Okay, I don't want to belabor this point, but the way I'm reading that, sir, is fuel, it's physical unavailability of the fuel. And indeed, in the Texas situation, as I understand, there was a restriction on natural gas supply to the power plants because of the extreme cold. And I'm assuming that's what they're referring to, that the gas simply wasn't there to deliver into the plant. So that's, again, to go back to my original point, that applies regardless of what we're talking about a parent company's merchant generation or a utilities generation, correct?
It applies, but the risk is entirely different. I mean, I think a regulated electric utility is able to earn a return on the capital invested in a generation asset. It's included in rates. Now, obviously, they're not going to earn fuel costs on a plant that's not running, but they'll continue to recover the capital costs. A merchant generator is only able to recover revenues by selling power. So to the extent that the merchant generator has no fuel and can't supply kilowatt hours to the grid, there's no income.
Okay, I don't want to belabor this. I'll try one more time, though. Availability, though, it goes not to the financial risks, but an operational risk. The plant can't run. The utility is relying on that generation for a portion of its load or all of its load. And again, this goes to the Texas situation where the gas doesn't show up, regardless of who owns that plant, whatever load is being served just can't be served, which is exactly what happened in Texas. Am I missing something?
No, I think that accurately describes the operational side of it. Then the utility is forced to find replacement power for whatever generating asset is not running. But I think the financial implications are much different for a merchant generator, which this is clearly discussing, versus a regulated utility.
Okay, I'll move on. Now I'll refer you to page 50 of your direct testimony.
Mr. Albert, are you still referring to this document on the screen?
No, I'm sorry, Your Honor. I will go up there and, okay, you took it down. Thank you.
I'm there,
Pulling up
Mr. Albert.
Okay, thank you. Now, let's see. I'm on on lines 12 to 16, 50, you addressed the non-utility proxy group, correct?
Yes.
And the last two lines of it is, in my opinion, referring to the non-utility proxy group.
Mr. Albert?
My opinion. Yes, sir.
When you turn your head, we lose your audio for some reason, and the court reporter.
Okay, sorry.
picked up that.
Thank you. Thank you. You say here, quote, this is a relevant consideration in evaluating just and reasonable ROEs for the company's electric utility operations, correct?
Yes.
Now, I want to briefly discuss with you, excuse me, if you go to your AMM-10, page 3.
Okay, I'm there.
Okay, this shows a list of the non-utility companies that you used in applying the DCF method, correct?
Yes.
Now, I want to briefly review with you, and I'll be pulling up documents which are Pepco's filings mostly, several components of Pepco's rates that are relevant to your assertion that a non-utility proxy group is a relevant consideration in this rate case in determining the ROE for Pepco. Turn first to the customer charge. You're aware that several of Pepco's rate schedules, including residential and commercial rate schedules, include a fixed monthly charge, which is often referred to as the customer charge.
Yes.
And be given, of course, but that it is a fixed charge, the customer is going to be paying this regardless of what their actual kilowatt hour usage is during the billing month, correct?
Yes.
Now, let's make this kind of, look at a competitive company. One of your competitive companies is Procter & Gamble. I'll call them P&G. Among others, they make household products, including laundry detergent, for example. They earn their revenue based on the amount of product they sell, correct?
Yes, that's correct.
So if I'm a buyer of Tide detergent and I'm buying like 2 boxes a month, and all of a sudden I drop my usage to 1 box a month, I'm not going to be paying I'm not paying any kind of fixed charge that would make up for the loss of revenue if there's a loss of decrease in usage. Is that correct?
That's correct.
Now I want to turn to another rate mechanism, the bill stabilization adjustment we've talked about, the BSA. And you'll agree that the BSA is a monthly positive or negative surcharge that's triggered if the base distribution revenue that Pepco receives from customers for the month is below or above the revenue authorized in Pepco's most recent rate case.
Yes, I'm not an expert on the BSA, but that, I believe that basically captures how that works.
Okay, you're on, Mr. Chairman, I want to pull up a recent BSA filing.
We'll transfer the rights back to you in a moment.
Thank you, sir.
Okay, you should have rights.
Oh, cool. It worked again. Okay. There we go. This is a BSA filing. Just, I mean, I know I gave a brief overview of it, but I thought it would be helpful, Mr. McKenzie, if you sort of give a real world application of this. This page.
Objection, and in large part, again, this is not a document that the witness created or he's familiar with. Keep it in mind, this is a company document that we filed with the commission.
Your Honor, this goes directly to the point. The Pepco is asserting that we should be looking at one of a relevant consideration. Their words in determining the ROE includes non-utility companies. That is, companies operating in a competitive market. And all staff is trying to do here with reference to a few of the rate mechanisms that Pepco has. Excuse me. The point being here that these distinguish a utility from a company in a competitive industry. So I think it's directly relevant to an issue raised by Mr. McKenzie by proposing a non-utility proxy group.
Mr. Albert, I recognize this is a staff exhibit, but is this an exhibit of a Pepco document?
Yes, this is a Pepco filing. I mean, this is from them. We circulated this on Friday, and last night we circulated it again, just so everyone would, if they didn't have the original email, they would have it. So this is a document they're well aware that staff would be using.
But keeping in mind, again, the witness is not familiar with this. He's indicated that he generally has some understanding of the BSA. He has no fundamental understanding of how it operates in the context of our rates.
Well,
And
I would
again,
say that
it goes back to the relevance. His testimony does not discuss the BSA.
Let me ask the witness, Mr. McKenzie, have you viewed this document that is currently on the screen?
No.
Your Honor, we did send this last night and specifically said that we'd be using this in crossing Mr. McKenzie. And this is relevant to his testimony. If he's not aware of the BSA, that frankly concerns me even more.
Mr. Albert, I agree with you. I'll allow you to inquire with him with respect to the BSA, but not any particulars on the document in front of us. Yes, you did provide it to Pepco in advance, but the witness has not reviewed it. He's not familiar with it. So if you could stick to a higher level, I'll allow your questions.
Okay, I was going to just, well, that's fine, Your Honor. The document speaks for itself. So we don't really need to go further on that. Now,
all right, so let's take the document down and then you can proceed with your questions.
Now, I would want to bring up another document now, going specifically to the BSA mechanism. Your Honor, can I do another share now?
I suspect you may trigger another objection, but we could see you have
okay
rights.
Thank you, Your Honor. This is from a document entitled, it's an Exxon document entitled Spring 2001 Investor Meetings. And the point here, I want to direct the attention of the witness to the line labeled decoupled, which is essentially the third heading down there. And just to make the point that this indicates that BGE, Pepco, Delmarva operations in Maryland, and Commonwealth Edison, which is the Exelon utility affiliate in Illinois, also have decoupling, which in this instance means a mechanism akin to the BSA to ensure full recovery of revenue despite decreased usage. Are you familiar with the fact that the other Exelon utilities do have these mechanisms?
Yes, as do many of the companies in the proxy group that I use to estimate the ROE.
Okay, now let me go down. Bear with me, page.
If you're referring to a document, it is not on the screen. We don't see anything.
Okay, excuse me, Your Honor. I'm looking for I'm going to scroll down. Is this document on the screen?
No, you're not currently screen sharing.
Okay, sorry about that.
I thought you perfected it a moment ago.
Yeah, I did too. Apologies. Okay, let me go back to the 10K. Okay, I'm going back to the 10K. Okay, I was a little confused there. I was looking for the right page and the wrong document. Is this screen shared, sir?
No, not yet.
Thank you. I think we're up now. Okay, I want to refer, this is again Exelon's Form 10K, the document we referred to before. And let's see, on page 35, bear with me, 2 more pages here. And this is where Exelon addresses the practical impact of its use, the fact that its utilities are using BSAs, or at least some of them. I'll note the first paragraph in this document starts the impacts of significant economic downturns. I refer focusing specifically on 2 sentences. First, this next sentence, further increases in customer rates, including those related to increases in purchase power and natural gas prices, could result in declines in customer usage and lower revenues for the utility registrants that do not have decoupling mechanisms. And also, if I could, and then the next, bear with me 1 second. This paragraph here, that registrants could be negatively affected by the impacts of weather. And they go, I will point to the sentence that begins 4 lines from the top. Due to revenue decoupling, BGE, Pepco, and DPL Maryland recognize revenues at the MDPSC, referring of course to this commission, and DCPSC, the Washington DC Commission, approved levels per customer, regardless of what actual distribution volumes are for a billing period, and are not affected by actual weather, with the exception of major storms. So again, you realize this is Exelon in disclosing the impact of a BSA, acknowledges that it does provide a significant protection of its revenue. Is that correct?
Yes.
Last document on, well, another document on this same point, one other tracker. And this, I think, is the last tracker I'm bringing up. Can I am I screen sharing, Mr. Chairman?
Can you hear me, Mr. Albert?
Yes.
Okay, I'm having a problem on my end, but yes, we could see you.
Okay, I'm pulling up a document. I guess I'll do share content.
Oh, the documents went away.
Yeah, let me try that again. Okay, thank you. Thank you, Chairman. Okay, this is a document, again, a filing by Pepco, December 31, 2020, where it's flowing through in its rates the cost it pays, or excuse me, the cost of transmission capacity, transmission service by upstream electricity transmission companies. And this is a flow-through mechanism via a tracker. If you look at the bottom line, it says total jurisdiction, and it lists, yes.
You undid your screen share. I think you hit the button twice, so it's not on our screen anymore.
Sorry, Your Honor. A pop-up came on my screen, and I think in getting rid of that pop-up, I got rid of the screen. Okay, if you look on the bottom line, line 24, And if you go over to column G as in girl, where it says G equals B as in boy times F as in Frank, go to the bottom number in that line, it lists that the total jurisdictional, that is costs associated with Maryland, are $112,814,221. You see that?
I see the number, yes.
And are you aware of this cost tracker that Pepco uses in connection with its transmission costs?
I mean, I'm not familiar with this document. I'm aware generally that there's a cost tracker associated with transmission costs.
Okay. I'll move on. Now I want to refer you to your direct testimony, page 12.
And Mr. Albert, if we're done with this screen, we should take it down.
Oh, sorry, Your Honor. I'm still working on this. Thank you. Sorry about that. I'll try to remember the next one. Let's see. Okay. You note this. I'm referring to your
Mr. Albert, we can't hear you.
Sorry, you're referring in this document to stock price volatility, correct?
Yes, and certainly anyway, characterizing the events in late March of last year.
And certainly in late March and certainly during other periods, stock prices are often very volatile. Is that correct?
Can you repeat the question, Mr. Albert?
Sure. I mean, you refer to the fact during the outset of COVID, we all acknowledge there was a significant volatility in stock prices, correct?
Yes.
And a stock investor is interested, really two focuses, of course. One, the dividend, the cash flow, and that's, of course, reflected in the discounted cash flow method you use. And that investor is also interested in appreciation of the stock price. That is an increase in the stock price, correct?
Yes.
Now, due to this stock price volatility, you would agree that the risk of a stock investment is reduced with respect to a company that's paying a regular and substantial dividend, correct?
Well, I think that, yeah, the extent to which a company pays a dividend does provide some amount of return that is separate and apart from the capital appreciation. So it would moderate it somewhat.
And indeed, the whole premise of the DCF method, discounted cash flow method, is for investors, and especially institutional investors that plan on holding a stock for a long period of time. Their focus is on that revenue stream, that is the dividend that they realize by holding the stock, correct?
Well, actually, under the DCF method, the revenue stream that you realize from holding the stock is the only determinant, because the DCF method is basically premised on a dividend payment into infinity growing at a constant growth rate. So that is the assumptions of that approach. Obviously, other approaches like the CAPM don't depend on that, but for the DCF model, that's the entire premise.
Right, and the DCF is a widely used method in across state commissions, correct?
Yes.
Okay, now if we look at your schedule AMM-4.
AMM, did you say AMM-4?
Yes, AMM-4, your direct testimony. And this shows, I'll wait till you get there.
I'm there.
This shows, going to that bottom line average, that our utility proxy group has a dividend yield on average of 3.8%, correct?
Yes.
Now, if we turn to AMM-10, page 1, bear with me while I pull that one up. Now, as compared to that 3.8%, our non-utility group has a much lower dividend yield of 2.4%, correct?
Yeah, it's lower. I mean, some of the companies in the non-utility group have a higher dividend yield than some of the companies in the utility group, but on average, it's lower. I agree with you.
Okay. And again, the higher dividend paid by utilities as reflected in these two numbers, the 3.8 versus the 3.8 for the utility proxy group versus the 2.4 for the non-utility group. That gives extra protection, I should say, especially as you acknowledged a few minutes ago, due to the fact that there are many periods of heightened stock price volatility. This provides important protection to investors, correct?
Yeah, I don't agree that that's the appropriate way to look at protection to investment. I mean, I think if we're talking about protection to investment, we should be looking at overall risk measures, which is what I focus on in my testimony. And when you compare the risk measures of the non-utility group to the utility group, they're actually stronger. And if you want to talk about volatility, we should probably be looking at beta, which is really kind of the more illustrative representation of how stocks move relative to the market. And again, the utility and non-utility groups are very comparable. So there's no basis in terms of overall risk to make a distinction between these groups of companies.
Though you acknowledged again that certainly for investors, one factor, and I certainly acknowledge it's not the only factor, but one factor is that dividend. That's essentially a steady, reliable benefit, especially for a long-term investor, that they will be receiving throughout the time they own the stock, correct?
Yeah, it's one factor, but I don't think it captures investors' overall risk perceptions. And I think those are portrayed in Table 5 of my direct testimony on page 52.
Okay, I'd like to move on if I could. Want to pull up, if I could, Chairman. This is again from the Form 10K. And I just wanted, thank you. On the bottom of page 56, I'll have to scroll down a bit. At the bottom of this page, this gives us data on the Exelon quarterly dividends 2019 to 2020. It's a fairly steady dividend, and in fact, it increased from 2019 to 2020, correct?
Yeah, that's correct. And I'd just like to clarify that going back to my earlier testimony, Exelon is not at issue in this case, and Exelon is not included in the proxy group, but I agree with your characterization of their dividends.
Right, and as a practical matter, Exelon, if one is investing in the utilities or wants to have an investment stake in the Exelon utilities, the way to do that is to buy Exelon stock, correct?
Yes.
Okay. Now, if I could pull up another document, Chairman. This is a document titled Winter 2021 Investor Meetings. Can people see that document?
Yes, we can.
Thank you. Just want to, again, hear Exelon talking. This is not the Form 10K. This is one called a promotional document. This is their presentation to investors. And here they note, top caption, met 5% annual dividend growth commitment through 2020. And then it shows in that chart the implied Exelon Utilities less holdco dividend. So this is indicating that Exelon has an aggressive program of increasing the dividend over time. Is that correct?
Yeah, I don't know if yes, that's true. I mean, it's showing an increasing stream of dividend payments, which I think is consistent with the utility industry in general.
And utility will try to maintain, if not increase, its dividend over time, even if it hits a bumpy road financially, knowing that investors, again, the long-term institutional investors that hold a large portion of utility stock, those investors are looking to the dividend because effectively that is their return for the long duration they'll be holding the stock, correct?
Well, I can't agree with your characterization of that being the return, since, as we discussed, the return is a function of what they receive as dividends and what they sell the stock for at the end of the holding period. So I don't know that we can characterize any one particular holding period for any group of institutional investors. But I certainly agree that the dividend is an important feature that investors focus on, and that management endeavors to maintain and increase dividend payments.
Okay, let me pull up one other document. Well, I have a couple more, essentially 3 more. Apologize for how this is kind of awkward here. Let me try to take this document down, stop sharing. Okay. Now this is a document from the Edison Electric Institute. Now, are you aware that the major utilities, including Exelon and other holding companies that own utilities, well, speaking specifically on Exelon, is a member of the Edison Electric Institute, which I'll refer to as the EI?
Yes.
And in fact, in June 2020, Exelon's chairman, Christopher Crane, completed a term as chairman of EEI. Now, let me just look at the data here on, this is the dividends of the EEI companies. That is those major utilities that are members of the EEI trade association. And this shows that the yield is 3.6%.
Mr. Albert, are we supposed to be
Yes.
looking at a document?
I'm sorry, am I not sharing this?
No.
Sorry. Let me try pulling that up again. All right, I've got it up. I'm having a little, okay, well, let's see. Oh, there we go. Still working on logistics here. Sorry. There we go. This is from a document entitled Electric Power Industry Outlook, February 10th, 2021, published by EEI. And they know that the average dividend, looking at that box in the middle, top box is stock performance, middle box is dividends. It shows that the yield is 3.6% for the EI companies, and that's pretty close to the 3.8% of your utility proxy group, correct?
Yes.
And this 3.6% is also significantly higher than the non-utility proxy groups. You're using your non-utility proxy group, that 2.3% dividend yield, correct?
Yes, it's higher.
Okay, let me move on to the next topic. Just 2 quick topics to go through. You're aware that this commission has authorized utilities to create a regulatory asset for recovery of COVID-related expenses and unpaid utility charges?
Yes, I am.
And you're aware that essentially, it's a placeholder. It allows you accrue these dollars in an account, which you can then seek recovery of in a rate case, correct?
Yes, sir.
I want to pull up a document. Again, this document I pulled up before the spring 2000. Okay, bear with me while I go to the correct page. Is this document up?
I can see it.
Excellent. The top words are utility highlights?
Correct.
Okay, thank you. Now I'm looking specifically in this context at the line labeled COVID regulatory COVID expense regulatory asset authorized. Do you see that?
Yes, I do.
And you see that that indicates that each of the, let's see, the 6 Exelon utilities have a regulatory asset for their COVID expenses, correct?
Yes, sir.
Now pull up, let me stop the share here. Pull up another document. This is a document. Let me pull it up first before I describe it. Is this document up on the screen labeled Staff Exhibit 14?
No.
Okay. Okay, apologies for the missteps here bringing it up. Okay, this is a February 1, 2021 joint filing at the Commission by Pepco and Delmarva Power and Light of a quarterly report on their incremental costs associated with COVID. And I'm on the 3rd sheet of this document, and specifically looking at that column. Top column says the top line is incremental costs due to waiver of disconnections. And then the next line, it says note 1, bad debt expense. And if you follow that across, that shows that there was a bad debt expense being put in the regulatory asset of $4,414,883, correct?
Yes.
And again, let's get sort of come full circle here. Comparing this to a company in a competitive industry, let's call it, Procter & Gamble, and if they're losing money, there's no mechanism, true-up mechanism that they can come in, they can impose a price increase in the market. If they do that, of course, they risk losing revenue and sales volume, correct?
Yeah, that's correct. But it's hard to make generalizations about things like bad debt expense. So, for example, if someone were to break a contractual commitment with a non-regulated company, there may be legal recourse to seek recovery of those dollars. So I don't dispute your very generalized statement, but again, it's not that there's no recourse available in the competitive environment if someone fails to pay an obligation.
Right, but let's assume Procter & Gamble, all of a sudden the company that sells them the chemicals they use for the laundry detergent increases the price significantly. Procter & Gamble will think, well, gee, we'd love to flow through that cost. They're constrained, as any company in competitive industry is, by the fact that they price their detergent above the market price that is established by their many competitors. They're going to lose sales and revenue, correct?
Well, that may be true, but the flip side is they have the prerogative. So unlike a regulated utility, which doesn't have any opportunity to adjust its costs or decide whether or not to provide service, a company in the competitive industry has much more control over those aspects of its business.
Last topic I want to touch on is related to the kind of range of reasonable ROEs. You and the other parties, of course, rely on multiple ROE methods to develop a range of reasonable ROEs, correct?
Yes, that's correct.
And there's a certain amount of discretion associated with choosing where in that range the actual ROE is established, correct?
Yes.
And there can be factors that can justify establishing an ROE at the upper end of the range. And you referred, when you were speaking with OPC's Mr. Alexander, you noted, or I think Mr. Alexander noted that Pepco, in a prior rate case, cited, I think it was 9406, you cited regulatory lag as a factor that justified an ROE at the upper end of the range, correct?
Yes.
Now, would there be factors that would justify an ROE at the lower end of the range?
I mean, there certainly could be, one example would be perhaps performance issues. I mean, regulatory agencies have lowered the ROE and placed it in the bottom end of the range due to a utility's poor performance on certain aspects, or if there was a case in which there was a demonstrable difference in the objective risk measures between the company and the proxy group, that could also justify that type of treatment. Those facts aren't in evidence here, but that is one example that could motivate that.
Okay, let me bring up a document, and this, I promise, is my last one. This is staff exhibit number 15. It's a report filed by Delmarva and Pepco on essentially unpaid bills, arrearages. And I want to note here specifically looking at bottom of where it's
Mr. Albert, we don't have
Yes,
it.
sir. Okay, sorry. I think I did that again. Do you see that now?
Yes, sir.
Okay. Now here, this bottom half, it talks about Pepco. And it notes that on the right-hand side, the takeaway column, it says roughly 21.4% of the overall customer base is in arrears, and 16.7% of this population is on a DPA totaling 21,019 for February, correct?
That's what it says, yes.
Okay, and are you aware that a DPA is initials for a deferred payment arrangement for people who are struggling to pay their bills?
I wasn't, but thanks for the clarification.
Okay. In determining the ROE, come full circle on this whole issue of where in the range of our reasonable ROEs is this probably frankly stunning number, 21.4% of the overall customer base is in arrears. Should that be taken into account in determining where in the range of reasonable ROEs we set the ROE for Pepco in this rate case?
Well, I don't think so. I mean, it sounds like the commission has instituted some policies to deal with the impacts of COVID. I mean, I think obviously under the regulatory paradigm that's established, the utility is granted an opportunity to recover its costs, and in exchange, it gives up control over whether it's going to provide service or at what price. So there's an exchange here, and the assumption is that if the costs are prudent, they will be recovered from ratepayers. So I think to the extent that recovery was going to be prevented and those costs would not be recovered, I think that certainly would imply a risk that's not considered in the average for the utility group. But I think in general, from what I see, regulators are responding responsibly with respect to COVID costs and are recognizing that utility shareholders shouldn't be bearing these costs.
So in other words, you would say this would not be a relevant consideration in establishing the ROE for Pepco in this rate case. That is to be specific here, the number of customers who are experiencing financial hardship and are in arrears. Is that correct?
No, I didn't say it's not a relevant consideration. I think you asked me whether it would justify setting an ROE in the lower end of the range, and my answer to that is no.
Okay, Your Honor, Mr. McKenzie, you have been a worthy person to cross. I appreciate the back and forth. I always learn things from your testimony. I appreciate the opportunity to talk with you today. That is all staff has, and Your Honor, if I'd like to introduce into the record staff's exhibits.
Yes, Mr. Albert, can you read off the exhibit numbers that you'd like to introduce?
Sure, Your Honor, and I'm pretty sure I've got these in sequence. The first was that Exelon Form 10K, which is pre-marked as staff exhibit number 33. Then the next exhibit was what we pre-marked as exhibit 13, which is the BSA filing by Pepco on February 16th, 2021. The next one is exhibit 12, which is Exelon's document entitled Spring 2021 Investor Meetings. The next exhibit is exhibit 16, December 31, 2020 filing by Pepco on the standard offer service rider. The next one is staff exhibit 11, which is an Exelon document entitled Winter 2021 Investor Meetings. The next exhibit is staff exhibit 17, which is the Edison Electric Institute document entitled Electric Power Industry Outlook. Next is exhibit 14, staff exhibit 14, which is the February 1, 2021 joint filing by Pepco and Delmarva Power and Light Company of quarterly report on incremental costs associated with COVID. And the last document is staff exhibit 15, April 1, 2021 joint filing by Pepco and Delmarva Power and Light Company of their monthly arrearage report for February 2021. Those are the 8 staff exhibits I would ask to be introduced into the record.
Seeing no objection, staff exhibits 11, 12, 13, 14, 15, 16, 17, and 33 are admitted into evidence. Mr. McKenzie, I recognize you've been on the stand since 11:35 this morning. We're going to take another brief recess, and then we'll give Ms. Hassan an opportunity for a redirect. Hope to have you off the stand by 3:30 this afternoon. We're in recess until 3 p.m. We'll get started in about 1 minute. Right, Ms. Hassan, are you back with us?
Yes, Your Honor. And I have no redirect for this witness.
Okay. Do commissioners have questions? Commissioner O'Donnell.
Thank you, Mr. Chairman. I think I have two questions. Hopefully the first one will be quick, although I hope I haven't just doomed that. Excuse me, let me get my camera up. Thank you. Mr. McKenzie, thank you for your patience, and we appreciate you testifying today. Can you go to page 3 of your direct testimony? At the top, Mr. Alexander asked you about your range, and you're describing your range of 9.5 to 10.8 in lines 1 through 5. And you described 10.2 as the midpoint between those two outer limits. But the true midpoint is really, of those two numbers, is 10.15, is it not?
Yeah, that's true. Basically, if we're doing one significant digit on the 9.5 and the 10.8, I think it's appropriate to round up, but you're exactly right.
Yeah, so it caught my eye, and I wanted to ask this question. There's no 5 basis point adjustment taking that up to 10.2. It's just, you're just rounding it up. Is that correct?
That's correct. Yes, sir.
Okay, because I noticed all the proxy groups, when their ROEs are recounted throughout the testimony by all the parties, including yourself, they're all out to 2 significant digits, out to hundreds. And you only go to tenths and you round it up to the company's favor. Why not just list it as 10.15?
Well, I think either presentation would be appropriate. I mean, in my view, if it was a 10.14, I would have rounded down. So I don't think there's certainly nothing inherent in the way I did it to benefit the company. It's just the math. In my view, the only reason I use one significant digit is, as the commission's aware, this is a pretty imprecise science. So the idea that we're going to capture investors' expectations out to 1/100th of a percent is a little bit of a stretch in my view.
Well, we have issued orders taking it out to 1/100th of a percent on our authorized ROE, so that's not unusual. And I just wanted to really verify that you weren't making a 5 basis point adjustment in your recommendation.
Absolutely not.
Okay, fair enough. Let me move off of that then. See, I didn't doom it. It was pretty quick. In your economic analysis of Pepco, and it's, you go in your testimony some detail about the world economic condition, unrest in the Middle East, COVID, a lot of things you talk about, but I didn't see anything that talks about the kind of the economic buffering that occurs in Pepco's service territory in some of the most affluent communities in the country around the National Capital Region in Montgomery and Prince George's counties that don't receive the economic roller coaster ride, if you will, that a lot of the nation does, including a lot of the proxy utilities you use, because of the presence of the federal government in the National Capital Region. I mean, the federal government isn't laying off employees, trust me. They're spending money hand over fist. And do you take that into account in your analysis of the economic condition facing Pepco?
Not explicitly. I mean, my analysis doesn't delve into a very granular examination of the economic situation in Pepco's service territory. I mean, I think as we saw by the exhibit that staff put up, you know, there's significant, obviously significant hardship and significant exposure to COVID-related issues facing Pepco with respect to payments and deferrals, that sort of thing. So it's not as if Pepco's immune to that, but I think obviously the risk measures that I'm looking at are at a much higher level, focusing on primarily the credit ratings.
I appreciate that. I'm not asking for your granularity, but it seems to me that the state of Maryland generally, and certainly the National Capital Region, has some economic buffering. We saw it in the revenue estimates for the state of Maryland, and I've seen this for decades serving in our legislature. Maryland is often buffered because of the federal government to the economic whims of the day, if you will, the ups and the downs, the cycle. We're not as affected by that. And I'm not asking for granularity, but you do talk about unemployment. You do talk about inflation. You do talk about other things. And Maryland, and specifically the Pepco service territory, as opposed to other parts of Maryland, are buffered from that to a certain degree. And I wanted to know if you took that into account in your economic analysis. I think I'm hearing you say, no, you don't.
Yeah, not specifically. I mean, I think, again, for my purposes and purposes of evaluating the ROE, it's appropriate to focus on a higher level of investment risk so we can compare Pepco across the industry. So with respect to those types of service area issues, certainly when the credit ratings evaluate the risks of the company, they do consider exposure to, let's say, industrial customers or undeveloped or economically challenged service territories. That would be a function of the credit rating.
Or the presence of federal agencies.
That's correct.
Which are large energy users, consumers of energy in the service territory.
That's right.
And they're pretty consistent in their consumption. So, okay, I'll let that go. I just wanted to make sure I wasn't missing something in reading your testimony and kind of trying to understand your very detailed analysis. One other thing I did want to ask you about, what is your opinion about where inflation is heading in this country? Do you have an opinion on that?
Well, I mean, I think to a certain extent, my opinion doesn't matter, but what I read about and what it seems like, if you look at what's happening in the financial markets over the last several months, there's obviously increasing concern that inflation, in fact, is going to be rising. Dr. Woolridge addressed this in his testimony and gave some statistics about the higher inflation that's been experienced in more recent months. And I certainly think that there is a side of the financial markets that are concerned that if the Federal Reserve keeps up its present policies, that inflation is going to accelerate well beyond the 2% benchmark that's been cited by the Fed for some time now.
Yeah, and you did talk about inflation to a certain degree in your direct testimony, and that's why I wanted to ask the question. And it's not just the Fed policy, but it's also energy policy generally, where you see diesel prices and gasoline prices, which affect transportation costs, which affects goods and services, which tends to accumulate on the side of higher inflation. And I think that's a significant point that we should keep in mind. And you really delve too much into your testimony on the subject, but you did mention it. So I wanted to ask about that a little bit.
Yeah, and I think that is, I mean, that's certainly what has been cited more recently for the rise in bond yields that we've been seeing in the last few months. You know, obviously a large component of the return that investors require from a bond is coverage to make up for inflation. So that gets translated directly into higher interest rates, which is kind of what we've been seeing over the last couple of months.
Yeah, very good. Thank you, sir. I appreciate your answers and the discussion, Mr. Chairman. That's all I have.
Thank you.
Commissioner Herman.
Thank you, Mr. Chairman. Just give me a second, Mr. McKenzie. Good afternoon, Mr. McKenzie.
Good afternoon.
I believe you were the witness in the BGE multi-year plan case, were you? Or were you
I
not?
was, yes,
You
yes,
were.
Your Honor.
Okay. Did you read the order that we issued in that case?
I absolutely read that order.
Okay. And, you know, tell me where you considered that order in your testimony.
Well, first of all, with all due respect
Briefly,
to
Mr. McKenzie, briefly.
okay.
Like are there pages I should be looking at where you said, I know the commission said this, but you know, I want to bring up this particular point?
Well, I certainly addressed the commission's dismissal of the ECAP-M and the size adjustment in my testimony directly. So that's an area where we clearly disagree, and I hope that I've addressed that in my testimony and responded to it.
Right. And did you address the commission's recent rejection of the non-utility proxy group?
I've responded to it as best I can. I mean, again, you know, the non-utility proxy group was not used as the basis of my recommendation. So it's a benchmark which I cite in support. It did not directly factor into my recommendation in the case.
Okay, so we can just toss that one out then, since it's not part of your recommendation.
Well, I don't think you should toss it out because I think it's an important benchmark. But
okay. So is there any basis in your view as to why we should treat Pepco any differently than we treated BGE?
Well, there's two primary reasons in my mind. The first is the credit rating. Pepco has a lower credit rating from Moody's than BGE, which suggests greater risk. So that argues for a higher ROE. I think the second is the pattern of bond yields since the time you decided the BGE case. Treasury yields are up about 60 to 70 basis points since then. Triple B utility yields are up about the same amount. So both of those things argue for a return above what was awarded to BGE.
Okay. And finally, I believe you said when you were doing rejoinder with Ms. Hassan that the multi-year plan is actually a positive way to address risk for a utility. Is it not? You did say
Yes.
that, right? Right.
Yes, I agree with that.
Okay. Thank you very much, Mr. McKenzie.
Thank you, Your Honor.
No additional questions. Does council have any questions for the witness based on the responses to the commissioners?
No, Your Honor.
Seeing none, thank you.
I'll try two. And if I'm out of bounds, I know you'll tell me.
Two.
Mr. McKenzie, you were asked on a number of different views about where inflation or interest rates are going, correct?
Yes.
Your Honor, it's going to be 3. That's the first. Okay. Do you follow the pronouncements of the Fed or the federal governors as part of your work?
Yes.
And would you agree that the Fed, whether the governors or whatever, have said that while inflation is going to, they're expecting it to rise now, but after a while they expect it with more recovery, the pandemic, to go down to more of the levels that it was experiencing before?
Well, I disagree with the last part. I don't think they're expecting it to go back down to the level it was experiencing before. They've enunciated a 2% target for quite some time now and recognized that they haven't got there. So they've changed their stance and said they're willing to allow inflation to exceed the target for periods of time. I would think that their expectation, I think their goal, long-range goal, would be to keep inflation within, close to that target. I think my discussion with the chairman earlier, with the commissioner earlier, was basically that I think there's some question in the markets right now, some concern that they may overshoot it by a considerable amount.
Your Honor, can I just ask him to answer the question?
Mr. Alexander, I believe your questions were following up from Commissioner O'Donnell's questioning. Is that
Correct. Yes,
Okay. All right.
it's just the last question. I didn't get an answer. I don't want a different question.
Mr. McKenzie, you need counsel to rephrase or repeat?
Yes, I do, because I think I answered it.
Mr. Alexander, let's try this one more time.
Okay. Hasn't the Fed made a pronouncement that while we're going to have some inflation over the next few months or half year, they're expecting that inflation to decrease somewhere in the nearer than further future?
Well, that's a different question than what you asked me the first time, because you asked me whether it would return to where it was before. And I made clear I didn't think it would. I think the Federal Reserve clearly has enunciated a 2% target. They are prepared to allow inflation to exceed the target for some period of time, but the expectation would also be that they would change their monetary policies, make them more restrictive as a way of containing inflation. So I think the 2% target still holds, and that if inflation exceeds it too much, they're going to do something to bring inflation back down again, and that might mean increasing interest rates.
Your Honor, it was a yes or no question, but I give up. I can't get a yes or no.
I don't think this witness will be giving you a yes
That's
or no.
fine.
We'll have to make
Thank
do
you.
with that response. The witness is now excused. Thank you.
Thank you, Your Honor.
Pepco may call its next witness.
Thank you, Your Honor. The company would like to call as its final witness Mr. Mark Warner to the stand.
Thank you, Mr. Warner. If you could please turn on your camera.
Good afternoon, everybody. Can you see me?
We can. Can you please raise your right hand?
Do you swear and affirm under the penalties of perjury that the testimony you're about to give in the matter now pending is the truth, the whole truth, and nothing but the truth?
I do.
Yes, Mr. Seegers.
Thank you, Your Honor. Could you please state your name and position for the record?
My name is Mark Warner. I'm a vice president at Gable Associates, and we
Mr.
are
Warner,
working as a consultant for the company.
Thank you. Mr. Warner, do you have before you the pre-filed direct testimony submitted on behalf of Pepco in this matter, which has been pre-marked as Pepco Exhibit 38, consisting of 75 pages?
Yes, I do.
Do you have any corrections or modifications to this testimony at this time?
No, I do not.
If I asked you the same questions today, would your answers be the same or similar?
Yes, they would.
Okay. And do you also have before you your pre-filed rebuttal testimony filed on behalf of Pepco in this matter, which has been pre-marked as Pepco Exhibit 68, consisting of 11 pages?
Yes, I do.
Do you have any corrections or modifications to this testimony at this time?
No, I do not.
And if I asked you the same questions today, would your answers be the same or similar?
Yes, sir.
Thank you. Your Honor, at this time, I would like to move into evidence Pepco Exhibits 38 and 68.
Hearing no objection, Pepco 38 and 68 are moved into evidence.
Thank you, and the witness is available for cross-examination.
Are there any parties that wish to examine this witness? Hearing none, do commissioners have questions of this witness? Thank you, sir. You are excused.
Thank you.
All right. Mr. Seegers, you stated that was the last company witness?
It was indeed, Your Honor.
Anything else before you rest?
I don't believe so.
Thank you. Office of People's Counsel, you may call your next first witness.
Your Honor, that would be Anna. She was on, but I think
Hi,
she's.
Gary.
You got it? You there?
Yes, I'm on.
Good. Okay. Bye-bye.
Okay. Your Honor, I've been looking at the clock and OPC has a couple of witnesses that are not available tomorrow morning. And so if it is all right with the commission and the other parties, I would like to change the order in which our witnesses testify in order to make sure that when we come back tomorrow morning, any witnesses that we still need to get through are available.
Okay, what is your proposal?
We would switch the order so that David J. Ephron would testify first, followed by Dr. J. Randall Woolridge. Then we would move to Melissa Whited, followed by Paul Alvarez and Dennis Stevens.
Do any of the parties object? All right, Ms. Ryan, let's begin with Mr. Ephron.
All right. OPC calls.
Actually, Mr. Chairman, can we give it a moment? I just need to check to make sure all our witness assignments are covered. And I was just trying to find the document in question. It shouldn't take more than a couple of minutes.
Okay, Mr. Spivak, as I understand it, no staff counsel will be crossing Mr. Ephron. Is that correct?
That is correct, Mr. Chairman.
Okay. Is there any reason for us to delay while you check?
No, I think we'll be okay.
Okay, thank you, Mr. Spivak. Ms. Ryan, let's proceed.
Okay, OPC calls David J. Ephron to the stand.
Good afternoon, Mr. Ephron. If you could please raise your right hand.
Can you see me?
Yes.
Let me turn you up a little bit here. Do you swear and affirm under the penalties of perjury that the testimony you're about to give in the matter now pending is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Mr. Ephron, good afternoon.
Good afternoon.
Do you have in front of you the direct testimony of David J. Ephron, which was filed in this docket originally on March 3rd, but the errata of which was filed on March 4th and is labeled as OPC Exhibit 8?
Yes, I do.
And just so the record is clear, the exhibit being, the testimony being entered as Exhibit 8 is the errata that was filed on March 4th. It is the number 32 of the documents listed in the docket. And the only difference between the errata and the initial testimony filed on March 3rd is that a couple of exhibits were inadvertently omitted from the original document, and they are included in the errata. Mr. Ephron, do you also have in front of you the surrebuttal testimony of David J. Ephron, which was filed in this docket on April 20th and is labeled as OPC Exhibit 9?
Yes, I do.
Supervision?
Yes, there were.
Are there any corrections that you need to make to your testimony at this time?
No, there are not.
And if you were asked the same questions today, would you give the same answers?
Yes, I would.
Your Honor, I tender the witness for cross-examination.
Are there any parties that seek to examine this witness? Hearing none, do commissioners have questions of this witness? Seeing none, thank you, Mr. Ephron. You are excused.
Thank you.
And Commissioner, if I might, I believe I neglected to move the admission of Mr. Ephron's testimony. I'd like to do so at this point.
OPC exhibits number 8 and 9 are moved into evidence.
Thank you, Your Honor.
Please call your next witness.
OPC's next witness is Dr. J. Randall Woolridge, and I believe Mr. Alexander will be serving for OPC while he testifies.
I will, Ms. Ryan.
Thank you, Professor Woolridge. If you could please raise your right hand.
Doctor, do you swear and affirm under the penalties of perjury that the testimony you're about to give in the matter now pending is the truth, the whole truth, and nothing but the truth?
I do.
You're a witness, Mr. Alexander.
Thank you. Professor Woolridge, would you kindly state your name for the record?
My name is the initial J, Randall Woolridge, and that's spelled Woolridge. I'm a professor of finance at the Pennsylvania State University.
Okay, and would you state the name of your business? Well, I think you did. The address and location.
My office is 302 Business Building, Pennsylvania State University, University Park, PA.
Okay, and Professor Woolridge, do you have before you a document entitled Direct Testimony of Dr. J. Randall Woolridge on behalf of the Maryland Office of People's Counsel, pre-filed in this proceeding on about March 3, 2021, comprising about 103 pages of narrative testimony, followed by an Appendix A, followed by exhibits JRW-1 through JRW-10.
I do.
And Your Honor, I would request that Professor Woolridge's direct testimony be marked as OPC exhibit. I think it's 10. Did I get it wrong?
I believe it is 10, yes. 10, marked as 10.
Thank you. Professor Woolridge, do you have before you a document entitled Surrebuttal Testimony of Dr. J. Randall Woolridge on behalf of the Maryland Office of People's Counsel, pre-filed in this proceeding on about April 20, 2021, comprising about 35 pages of narrative testimony?
I do.
Your Honor, I would request that Professor Woolridge's surrebuttal testimony be marked as OPC Exhibit 11.
So marked as exhibit number 11.
Professor Woolridge, were each of these documents that are before you either prepared by you or under your supervision and direction?
Yes, they were.
And do you have any corrections or deletions to make to either of these two pre-filed prepared written testimonies, respectively?
I have one typo, or I guess a number mistake, but it's not used in any way. If you go to exhibit JRW3, page 1. In panel A, Pepco's proposed capital structure should be long-term debt 49.5%, common equity 50.5%.
And is that the only correction?
On the same page in panel 4, the same change, long-term debt 49.50%, common equity 50.5%.
Are there any additional ones?
That's it.
Okay. And well, with these corrections, just to be clear, you have adopted Pepco's proposed capital structure, correct?
Yes, I have.
Okay. If you were asked the same questions today under oath as were posed in each of your pre-filed prepared testimonies, would your answers be the same?
Yes, I would.
For these reasons, do you adopt your prepared written direct and surrebuttal testimonies, respectively, as your sworn testimony in this matter?
I do.
Your Honor, I move that these two documents be admitted as evidence into the record of this proceeding?
Hearing no objection, OPC exhibits 10 and 11 are moved into evidence.
Your Honor, the witness is now available for cross-examination.
Thank you. I believe Ms. Hassan will begin with the cross.
Yes, and thank you. Good afternoon, Dr. Woolridge. I believe we've met a couple times.
Well, I believe we have. Excuse me.
Yes, sir. And reviewing your resume, and I'm looking at this now, you have had two primary pursuits in your career, one being a professor at Penn State and the other as working as a consultant providing analysis and testimony before various state and federal regulatory commissions. Is that correct, sir?
Yeah, I've also done a lot of consulting internationally for companies, primarily a lot of it's involving like teaching finance to executives in different countries around the world, that sort of thing. That was another pursuit of mine over the years.
Okay, and I believe also, don't you also have a software and a book that you sell to educate those on stock prices and evaluation of stocks?
I do, yeah. We maintain a website as well, yes.
Okay, and reviewing your resume, it does not indicate that you've ever worked for a regulated utility. Is that correct?
I have not. In the past, I mean, I haven't in a text as a witness. I've worked for some utilities in terms of consulting, mainly kind of financial issues with utilities, Con Ed being one of them. But that's been a number of years since I worked, and that was not testifying at all.
Okay. And you have no experience as a state or federal regulatory commissioner. Is that correct?
No, I do not. I've testified in probably 30 states, but I've never been on that side of the chair.
Okay, and you frequently testify, as you just said, as a cost of capital witness in regulated utility proceedings. Is that also correct?
I do.
Okay, and in such proceedings, is it not unusual for the company witness and the consumer advocate witness to disagree on their recommended ROEs?
Yeah, most assuredly so. Yes, I agree with that.
All right, and is it not also unusual for the cost of capital witnesses to use different econometric models?
I think, yeah, there's a fair amount of judgment in terms of the models, the inputs in the models, and how you interpret those results.
Okay, but notwithstanding this difference amongst the cost of capital witnesses, ultimately, is it not true that the determination of an appropriate return on equity is decided by the commission?
That is correct.
And in this case, that decision will be made by the commissioners we are appearing before today, correct?
Yes.
Okay, and you've noted that you have served as a witness before this commission before. Do you know approximately how many times you've appeared as an ROE witness?
I would say it was probably 7 or 8 times in cases involving Pepco, involving BG&E, and involving Delmarva.
Okay, and in those proceedings, do you recall if you have ever recommended an ROE for the utility that is more than 9.0%?
I don't recall all the cases, but I would say probably 9% is as high as I've been.
Okay. And let's try to jog your memory. Do you recall in 2016 in the DPO rate case, you were a witness? Do you recall that first?
I believe I was. I'm not sure. I would say probably I was, but I would assume it is. Yes.
Okay. And do you recall that the commission in that proceeding approved an ROE that was 100 basis higher than your recommendation?
Yeah. I mean, I saw Pepco Exhibit 66, which listed a series of cases in Maryland with the OPC recommendation and the commission approved ROE. And I see on that list DPL is there, and it is based on the data here that that I recommend 8.6 and the commission approved 9.6.
Thank you. Well, since we're speaking to that document, let's speak to Pepco Pepco exhibit that's been identified as Pepco 66, Maryland Electric Distribution Company return on equities. Let me know when you have that before you.
I do have that.
Wonderful. Okay, also looking at case 9610. Do you see that? It was
Yes, I do.
adjudicated in 2019.
Yes.
And are you aware that OPC agreed in its settlement to an ROE that
Ms.
was
Hassan, you went way too fast for me.
I'm
Now I
sorry.
finally got to my exhibit file, so tell me what Pepco exhibit we're looking at and the page number, please.
66, and it's only one page.
Thank you.
And specifically, I'm referring to case number 9610 that was adjudicated in 2019.
Your Honor, I'm going to object because I believe Ms. Hassan said that this is a document arising out of a settlement. And so settlements are not precedent. Then, so if there's any questions about the ROE or anything in a settlement, by the terms of the settlement themselves, you can't you can't submit them or offer them. But also because a settlement is a negotiation of compromise, and it's impossible to know, other than the people in the room, what was being compromised to arrive at a certain ROE or even capital structure. And even if you did know the people, it's confidential and they're not allowed to tell you. It might have even been me, I don't know.
If I could pose my question, because I think Mr. Alexander was sort of premature in his objection.
Well, let's hear the question, and then I'll make a ruling.
Thank you, Your Honor. In case number 9610, in which you were OPC's ROE witness, are you aware that OPC agreed in a settlement to an ROE that was 90 basis points higher than the ROE that you recommended?
Your Honor, I renew my objection and move to strike it.
Again, it's just if the witness is aware of the facts. I did not ask if the witness was aware of the negotiations or the compromises that went into that settlement.
Ms. Hassan, so I'm looking at 9610, which was a 2019 rate case. OPC recommended ROE was 8.7. The settlement ended up, this is a matter of record, settlement ended up at 9.7. So that's a 100 basis point increase based on OPC's recommendation. Did you just say 70 basis points? Or did
No, my math was wrong. I said 90, and seemingly I may have been off. Let me count. It's 100 basis points. Sorry, I was looking at my wrong line number. You're correct.
All right. Ask your question one more time, and the witness should not respond until I say so.
Okay. In case number 9610, OPC agreed in a settlement to an ROE that was 100 basis points higher than the ROE that you recommended, correct?
Well, now, yeah, I'm not going to allow that that question. The witness is not OPC. He did not sign the settlement. He's just he's a consultant, an expert witness for OPC. So, Mr. Alexander, your objection is sustained.
Okay, and I won't even try to rephrase that one. Just one last question, being that it is late in the day. Dr. Woolridge, are you aware if this commission has ever adopted any of your recommended ROEs?
I'm aware that in all cases I've been involved in Maryland, the commission has looked at my recommendation, the company's recommendations, and usually they've been in, certainly not at one end or the other, usually pretty much between the two parties. And it's consistently, on pages 6 and 7 of my direct testimony, I go through all the former Pepco cases going back to 2010. Now, we don't have my recommendations in there, but it simply shows kind of where the commission came out. And certainly Pepco Exhibit 66 shows that I've been below the average or below the recommended ROE, and it doesn't show it in that exhibit, but the company ROE witnesses have consistently been the 10.2, 10.3, 10.4 or 5 range.
Was that a yes or no to my question?
Oh, I'm sorry, ma'am, yes.
Do you want me to
No,
rephrase
I
the
have
question?
never, I'm sorry, let me preface, I should have started by saying no, they've never recommended I apologize.
No problem, and thank you for that. And with that, Your Honor, I ask that we move into the record Pepco Exhibit 66.
Did we use Exhibit 66 for anything in your questioning?
I was referring to 66, yes, sir, and we were discussing case number 9610, as well as another case. It was the 2016 case for DPL.
Mr. Hassan, what's the exhibit number? I'm sorry.
66.
Okay, I've got 69, 71, 66.
Okay, we did have discussion on that 2016 DPL case 9424. Mr. Alexander, do you have anything to say?
Am I looking at 66 or 56? I'm sorry.
66.
All right, so 66, is that the one entitled Maryland Electric Distribution Company Return on Equities?
That is correct.
Okay, and yes, Your Honor, I'll object because there's nothing, first of all, to say what this document is.
I think the
It's
title
not been authenticated by Professor Woolridge. Now, if this is a page in his testimony, then of course I would withdraw the recommendation. But I'm still not sure what this is and what it has to do with OPC witnesses O'Donnell and Parcell have to do with this case. I don't know either. So yes, I would object to this as it stands in this document.
Professor Woolridge, were you the expert in case number 9424, the DPL case in 2016? You're on mute.
Sure. Subject to check, I would say yes, I was. I mean, I was involved in a number of cases. I don't remember that one specifically, but I was involved in a number of cases. And if the company is aware that I was, I could check my records, but it would take a couple minutes.
Your Honor, if I could speak to
Hassan?
this. With respect to Pepco exhibit number 66, Professor Woolridge was the witness for OPC in all of the proceedings except for in case 9602, where it indicates that witness Kevin W. O'Donnell represented OPC,
Okay.
as well as in the
Okay,
next case.
That's enough. Mr. Alexander, I'm going to overrule your objection. If it was just with respect to 9610, I would agree that this exhibit comes out. But Professor Woolridge was the witness in the DPL case, and there was some discussion of that. So Pepco Exhibit 66 is entered into evidence.
Oh, I can't, I'm not allowed to respond unless you granted and you haven't, so I stop.
We'll move along.
Okay.
Thank you, Mr. Alexander. Ms. Hassan, any other exhibits?
No, Your Honor, thank you. And no further questions for this witness.
Any other parties wish to examine this witness? No. Any redirect, Mr. Alexander?
Yes, because actually, Ms. Hassan brought out something that I didn't specify. Professor Woolridge Are you testifying today in your position as a professor at Penn State University or as an independent consultant where you have your own business that's separate from your teaching responsibilities?
It is separate from my teaching responsibilities.
Okay, that's it, Your Honor.
Do commissioners have questions of this witness? Commissioner Richard.
Thank you, Mr. Chairman. Yeah, just a quick question. I wanted to ask Mr. Woolridge about his comment on page 35. I understand that the capital structure is not in debate, but he does make this comment. However, in setting an ROE for Pepco, the commission should recognize the company's proposed capital structure includes a common equity ratio that is larger than other electric utility companies. And I wanted to ask that question. Also thinking about Mr. McCullough's discussion about the, a recent, I guess, long-term debt that was secured by Pepco at 3.29%, and just want to find out what should I take from that that question or that comment you make about the commissioner should take this into consideration.
Oh, thank you, Commissioner. Yes, actually, I would point you to in my direct testimony between pages 28 and 35. I talk about the significance of the equity ratio. Initially, I compared the equity ratio proposed 50.5 to those in the two proxy groups, in the electric proxy group and the McKenzie proxy group. And I show the 50.5% common equity ratio is higher than what these companies currently. So they have more financial risk than the than proposed for Pepco. I also in Exhibit J3, I go through and track the capital structures for Pepco and for Exelon over the last 3 years, just to see if they've maintained a capital structure that's along these lines, and they have. I just say it's less financial risk. I mean, it's more financial risk, less financial risk because it has a higher common equity ratio than other electric utilities. Now, that being said, I've accepted it, but recognizing you have a higher common equity ratio, usually, commissions will take that into account when they set the ROE.
Great. Thank you very much. And again, this question is not in dispute, but are we missing an opportunity here by setting this high common equity number? I mean, given that the debt opportunities are historically low.
Excellent. I discussed this in my testimony. Pepco and the other subsidiaries, BGE, Belmar of Exelon, have been raising capital. Why not raise capital now? Interest rates are low. When I show in my testimony on page, on page 18, I show utilities are raising records amounts of equity and debt. Now, and exactly, if you go back and look at month by month in 2020, when interest rates crashed in the month of March, utilities raised a lot of cheap debt. Why? Because they could they could issue 30-year debt below 3% at one point. So, I mean, rightfully so, they went out and raised a lot of debt and lowered their overall debt cost rate. But it was an opportunity to get low-cost capital, and utilities clearly had access to the capital markets. And so that's why I think it's good. I mean, and also I think, Commissioner, I'd point you to page 7 of my testimony, where I go through the history of Pepco over the last 10 years, their rate cases, which have their capital structure and their ROEs. And I show whether, if the commission made some adjustments based off of flotation costs or, adjusting for risk mechanisms and that sort of thing. I think it's a helpful guide for the commission to look at when they're looking at how Pepco, where they've been over the last decade with the commission.
Thank you, Mr. Woolridge, and thank you, Mr. Chairman.
Mr. O'Donnell.
Thank you, Mr. Chairman. Professor Woolridge, every time I hear you testify, I want to start my question to you with a hearty "we are," but I won't do that here. So
I like that. Well, the Terps are coming along. I hear that from
yeah. We love
my
the Terps.
attorney all the time.
We love the Terps too. So my question to you is, did you hear the discussion I had with Mr. McKenzie about the buffering in the National Capital Region and the federal presence and how that may affect some of the analysis, and did he take it into account? Did you hear all that?
I did.
In your direct testimony on page 98, you say that the question is, what are the issues with Mr. McKenzie's risk premium? And you say in lines 10 through into 11, Mr. McKenzie's URP approach is a gauge of commission behavior, not investor behavior. And then you go on later in that paragraph to talk about externalities included by Mr. McKenzie, such as service territory and a lot of other things. Are you suggesting by saying that it's a gauge of commission behavior, not investor behavior, that we shouldn't take those into account? Or what are you saying there?
No, Commissioner, I think it's a real good point. The point I'm making on page 98, now I want to talk about one other issue I brought that relates to this. On page 98, I talk about the risk premium is based off of authorized returns on other, mostly in other, few in Maryland, but mostly in other states. And, every commission that I've testified before, they take into account
I think we've lost the professor.
I'm sorry, I'm not muted. Did I come back yet?
Yes. You did, but you froze.
Sorry. I said every state, every rate case, you go over thousands of pages of testimony, get into details about all the elements about depreciation, rate base, all these issues. And these are brought into the ROE at some point. So, and in the end, I think commissions say, well, we think capital structure, we think, depreciation, we think all of these things should be taken into account when you set the overall profitability, which is the ROE. I think, on the other hand, the markets determine capital costs, not commissions. Commissions are trying to read that, but they're trying to adjust for unique situations of, say, Pepco here versus, a utility in California or Texas. Everybody looks at its unique risk. Now, to your point about the Pepco and the service territory and that sort of thing, I think a good reference point on that, if you go to page 10 of my rebuttal testimony, I show the 5-year financials for Pepco. At the top, I show their S&P and Moody's credit rating. And as I discussed below, they have very solid performance. Now, they're only earning an ROE about 8.5%, but they have, strong S&P and Moody's ratings. They're issuing capital, they're raising debt, equity, that sort of thing. So, and obviously part of that stable performance is a function of how, the rate-making mechanisms, everything built into that in Maryland. And also it's a function of obviously a pretty steady business environment so that you don't face a lot of up and down, but they've achieved tremendous, very solid financial results. They're not earning an ROE of 10.2%, it's 8.5%, but very consistent. You look at the credit ratios and everything, very solid performance. And part of that is obviously the regulatory environment. It's also the economic environment.
Thank you for that, Professor, for that clarification. I appreciate it. Thank you, Mr. Chairman.
Council have any questions resulting from the responses to the commissioner's questions?
No, Your Honor.
No, Your Honor.
Seeing none, the witness is excused.
Thank
Mr.
you.
Al- Who is your next witness?
OPC's next witness is Melissa Whited.
Okay, if she's available, there she is.
She's
Ms.
available.
Whited, if you could please raise your right hand.
Do you swear and affirm under the penalties of perjury that the testimony you're about to give in the matter now pending is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Your witness, Miss Ryan, and I'm sorry, Miss Ryan, just for the list, who's after this witness?
After this witness, we have the panel testimony of Paul Alvarez and Dennis Stevens. And then with respect to OPC's two remaining witnesses, Jerome Mirswa and Courtney Lane, the parties have agreed to stipulate to the admission of those witnesses' testimony because nobody has questions for them.
That's right, and I was going to check with the commissioners to see if they would stipulate as well. Are commissioners in a position now to, let me ask this, does any commissioner wish to examine either witness Lane or witness Mirswa? No. Okay, so those two witnesses are excused. This will be our last witness of the day. We'll take the panel witnesses first thing tomorrow, and then we'll turn to other parties. Ms. Ryan, you may proceed.
Thank you, Your Honor. Good afternoon, Ms. Whited.
Good afternoon.
Do you have in front of you document labeled as the direct testimony of Melissa Whited, which was filed in this document on March 3rd and is labeled as OPC Exhibit 4?
Yes.
And do you also have in front of you the surrebuttal testimony of Melissa Whited, which was filed in this docket on April 20th and is labeled as OPC Exhibit 5?
Yes.
Were these testimonies prepared by you or under your supervision?
Yes.
Are there any corrections you need to make to either of these documents?
No.
And if you were asked the same questions today, would you give the same answers?
Yes.
Thank you. Your Honor, I would like to move the admission of OPC Exhibits 4 and 5, the direct and surrebuttal testimony of Melissa Whited.
Hearing no objection, OPC Exhibits 4 and 5 are moved into evidence.
Thank you. And Your Honor, with that, the witness is available for cross-examination.
Thank you. We'll begin the examination by counsel for Pepco.
Thank you, Your Honor. Good afternoon, Ms. Whitehead.
Good afternoon.
I'm Matt Seegers, and I'm appearing on behalf of Pepco, and I'd like to ask you a few questions about your testimony. Could you please turn to page 6 of your direct testimony? And I'm looking at the discussion beginning at line 15. Let me know when you're there.
I'm there.
Here you discuss the difference between traditional cost of service regulation and the MYP construct as it pertains to regulatory lag. Isn't that correct?
Yes.
Okay. And on page 7, line 1, you state that the risk of disallowance in an MYP is small, correct?
Yes.
Are you familiar with the Baltimore Gas and Electric MYP proceeding in case number 9645 before this commission?
Yes.
And isn't it correct that the Office of People's Counsel, on whose behalf you are testifying today, took part in that proceeding?
That is correct.
And isn't it correct that the Office of People's Counsel had the opportunity to review BGE's capital spending plans in that proceeding?
That is my understanding, yes.
Okay. And isn't it correct that Mr. Alvarez and Mr. Stevens submitted testimony on behalf of OPC in that proceeding, recommended numerous disallowances of BGE's reliability spending?
Your Honor, this witness was not a witness for OPC in the BGE proceeding, and she is not qualified to testify about what other people testified on behalf of OPC in that previous proceeding.
Mr. Seegers, where are you going with this line of questioning?
Your Honor, I'm just looking to see if this witness has testified that the risk of disallowances in MRPs is small. I'm simply exploring her knowledge of what happened in the BGE MYP proceeding, which is the only other MYP proceeding this commission has heard.
You may proceed if the witness is aware, if she's aware. If not, she'll say she's not.
Understood. Do you need me to repeat the question, Ms. Whitehead?
Yes, please.
Okay. Isn't it correct that Mr. Alvarez and Mr. Stevens submitted testimony on behalf of OPC in that proceeding, being 9645, recommending numerous disallowances of BGE's reliability spending?
I'm not aware of that.
Okay. Well, are you aware of the commission's order in that proceeding?
Yes.
Okay. And isn't it correct that in the BGE MYP proceeding, the commission made it clear that it was not pre-approving any particular work plan or project for purposes of prudency?
Yes.
And isn't it also correct that the commission has also stated in its order that the issues OPC raised in that proceeding, including whether particular projects will ultimately benefit ratepayers and whether actual project costs are excessive, will become ripe for prudency review during the reconciliation process?
Yes.
Okay. And isn't it correct that if it's determined that any of those projects are imprudent, they would be at risk for disallowance?
Yes.
And isn't it also correct that the commission directed BGE to extend the spending timeframe or budgeted increases of several work plan budgets from 3 years to 5 years?
That is my understanding.
Okay. And the commission stated that it was taking these measures to avoid an unduly burden to BGE ratepayers at a time of economic stress.
Yes.
Okay. And you're not stating that the commission did not undertake a thorough review of BGE's capital spending plans in case number 9645, are you?
I'm not stating that.
Okay. And you're not arguing that the rates approved by the commission in case number 9645 are not just and reasonable, are you?
That's not my argument, no.
Okay. Could you please turn to page 11 of your rebuttal testimony, ma'am? And I'm looking at the discussion beginning at line 12. Let me know when you're there.
Page 11, line 12.
I'm sorry, Mr. Chairman. Were you saying something?
Sorry, you said page 11, line 12?
That's correct, Your Honor.
I'm there.
Okay. Here you respond to company witness McGowan's statement that order number 89638 provides that only the utility filing a rate case may propose a PIM. Is that correct, ma'am?
That's correct.
And you state that Mr. McGowan is incorrect because the metrics you propose in your direct testimony are not PIMs. Is that correct?
That's correct. The metrics do not contain any financial incentives.
Okay. And you further contend that the metrics that you propose in your direct testimony are permissible because they will not have any implications for rates. Is that correct, ma'am?
That is correct.
Okay. Now, let's just put to the side the issue of interpreting the commission's order just for the moment. Have you reviewed the commission's order 89638 in which the commission approved performance incentive mechanisms?
Yes.
And isn't it correct that on page 14 of order 89638 at paragraph 30, the commission states that any proposed metrics, milestones, and reporting of PIMs should be clear and well-defined, unique for each utility, designed so they are not easily met and benefit ratepayers?
Yes.
Now, isn't it correct that each of the metrics proposed by the company in this proceeding has a specific target goal for each year of the MYP, along with an upper and lower limit that establishes the overall performance target range?
Yes, they do.
And starting on page 35 of your direct testimony, beginning at line 10, I'll give you a moment if you want to go there.
You said page 5, line 10?
I'm sorry, page 35
35
of your direct testimony, ma'am, beginning at line 10.
Yes.
Here you propose 5 metrics related to the deployment of non-wires alternatives and 2 metrics related to, as you phrase it, customer empowerment. Is that correct, ma'am?
That's correct.
But in contrast to the company's proposals, you don't specify any specific targets for any of the metrics that you propose. Isn't that correct?
That is accurate. I'm proposing tracking metrics. I'm not proposing any specific targets.
Okay. And as a consequence, you don't make any attempt to show that the metrics that you propose are unique to Pepco or designed so they are not easily met. Isn't that correct?
That's correct.
So just so I'm clear, you're merely proposing that the commission require the company to track the metrics that you propose. Is that correct?
Yes, the rationale for proposing metrics is to provide information that could potentially inform future PIMs, but generally provide more information to the commission and to stakeholders regarding Pepco's performance in certain areas, specifically non-wires alternatives and customer empowerment.
Okay. But notwithstanding the commission's statement on page 14, paragraph 30 of order number 89638, that, quote, since only a utility may initiate a PIM, the commission will not require utilities to collect and report data based on its potential value for future PIMs, unquote.
My understanding is that was in the context of the working group's report, where specific tracking metrics were proposed there. And that's what I understand the commission's order to be referring to.
Okay. But you would agree with me, ma'am, that the commission has determined that it is not going to require the company to track specific metrics that are not proposed by the company?
Objection, Your Honor. This calls for a legal conclusion. This witness is not an attorney.
Rule, I don't believe it is necessarily a legal conclusion. If the witness can answer, she may.
My understanding is that the order was not requiring the tracking metrics that were proposed in the working group report. Not that the commission said that it would never require the tracking metrics to be implemented.
Okay. Okay. Could you please turn to page 12 of your rebuttal testimony, ma'am? And I'm looking at the discussion beginning at line 6. Let me know when you're there.
I'm there.
Starting here and going through to page 14 of your rebuttal testimony, you discuss how you believe the company's EV, GHG, and FCR metrics are inappropriate to be considered PIMs. Is that correct, ma'am?
That's correct.
Okay. Now, is it fair to say that you've reviewed Mr. McGowan's rebuttal testimony in this proceeding?
Yes, I did.
Okay. And specifically on page 19 of Mr. McGowan's rebuttal testimony at line 16, he states that in the company's next MYP, it may propose a continuation of the same or a subset of PIMs presented in this case, and that the company may propose additional PIMs. Do you remember that testimony, ma'am?
Yes, I do.
Okay. And you're not disagreeing that the company has that ability under order number 89638, are you, ma'am?
To propose the continuation of PIMs or new PIMs?
That they may propose the PIMs that are consistent with the metrics proposed in this proceeding. It could be a subset of those PIMs, or it could be different PIMs, ma'am.
I agree.
Okay. And isn't it also correct that in the event that the company does propose PIMs in its next MYP, that all interveners, including the Office of People's Counsel, will have the opportunity to review and propose modifications to those PIMs?
Yes.
Okay. Thank you very much, Ms. Whitehead. That's all I have.
Does any other party have examination of this witness? Ms. Ryan, do you have any redirect?
Just a little, Your Honor. Ms. Whitehead, counsel for Pepco asked you a number of questions based on the order in the BGE multi-year rate case. Do you remember those questions?
Yes.
And he seemed to suggest that there was a there's a discrepancy between what the commission said in that order and your comments about the, like the likelihood of non-recoverability or of projects being deemed imprudent. Can you explain that discrepancy between what you read in the order and what you wrote in your testimony?
Yes, so I understand that the commission has stated clearly that the projects would not be pre-approved and that there would be a prudency review at the reconciliation process. However, I maintain, as I stated in my testimony, that showing that a project was imprudent is very difficult, and it shifts the burden to the parties who are trying to demonstrate that something was imprudent. To do so requires that you have knowledge of what the utility knew when, and that you're able to show that at the time of when the decision was made, that the company had knowledge that a project was either unnecessary or in some way imprudent. And that's a very large burden of proof. And at that point, to demonstrate that requires a lot of effort and, frankly, a lot of information that stakeholders often don't have. And that is what I was referring to in my testimony.
Okay, thank you. That's all the questions I have, Your Honor.
Do commissioners have questions for this witness? Commissioner O'Donnell?
Briefly, Mr. Chairman. Good afternoon, Ms. Whited.
Good afternoon.
In your direct testimony on page 11, in response to a question of other commissions required utilities to undertake integrated distribution planning, you chronicle page 11 down through the end of page 13, 4 states: Michigan, Minnesota, California, and New York, and what commissions have required in this regard in those states.
Yes, sir.
If you know, can you tell me which of those states, if any, are vertically integrated and which of those states are restructured?
Yes, sir. So New York is restructured, and California is more or less vertically integrated, although they do have some markets. Minnesota is still largely vertically integrated, although it is in MISO. And same in Michigan, I believe Michigan is in PJM. And I'm not aware of, I don't recall whether the utilities own generation there or not.
Yeah, they're not in PJM, but I don't know. I have to look that up. But you talk in terms of integrated distribution planning, and I want to make sure I understand how you use that term. Maryland used to do integrated distribution system planning with regard to when we were a vertically integrated state. We had to make sure that that was all done. It's a competency that the commission doesn't have anymore because we're restructured. So the restructured states approach this generally very different than vertically integrated states. And I wanted to check your understanding of how you're using the terminology integrated distribution planning.
Yes, sir. And so integrated distribution planning, I see as distinct from something that's often referred to as integrated grid planning, which tries to combine both the supply side generation resources and that planning with the distribution planning and merge them more together. With integrated distribution planning, I'm really referring to on the distribution system, we have all these different resources now. We have distributed energy resources that are changing the way that power flows. It's not just flowing one way to customers. The power is flowing back onto the grid from batteries, from solar, and you have resources such as electric vehicles that could also potentially provide power back to the grid. So incorporating all of those different resources is what I mean by integrated distribution planning. Instead of energy efficiency being siloed over here and electric vehicles being siloed over here and batteries here, you bring them all together and you look holistically at how can we best manage the grid, manage the distribution system, and find cost-effective alternatives. So to do that, you really need to do planning across multiple dimensions. You can't just look at load forecasts of customer load that's growing. You also have to look at the load modifiers, all the distributed energy resources, and whether they could also, be relied upon instead of traditional utility wire solutions to provide services back to the grid.
Well, thank you for that. I just wanted to level set and make sure I was reading the terminology and the way I understand it as opposed to the way you understand it. You are aware of the NARUC-NASIO DOE task force that recently completed a 2-year process on distribution system planning, I'm sure.
Yes.
And are you aware that Maryland has integrated yet another working group in our Grid of the Future PC44 to do almost, well, I won't say exactly, but to consider a lot of what you're recommending here in a one-stop stakeholder, utilities, consumer advocates. I'm sure OPC is going to be well involved in that process. You're aware that we've initiated that process, right?
Yes, sir, and I commend the commission for doing that. I think the time is absolutely ripe for doing so. I think the more transparent planning process that really considers the full range of solutions is critical for protecting ratepayers and for ensuring that investments are cost effective and that we're planning to meet Maryland's policy goals.
And I'm sure you would agree that transparency is a critical component of considering all of those things and coming up with maybe a potentially new way of how we approach, in the light of these multi-year rate plans, distribution planning.
Yes, I would agree. I think it's more critical than ever in light of the multi-year rate plans to have greater transparency so that we understand what the utilities are proposing and whether it's really the best solution for ratepayers.
Thank you. Thank you for that. Thank you, Mr. Chairman. I have no further.
Any questions based on Commissioner O'Donnell's questions? Seeing none. Ms. Whitehead, you are excused. Thank you.
Thank you.
All right, we are done with witness examination for today. Ms. Brennan, are you with us still?
I am, Your Honor.
Earlier this morning, you had that one exhibit. Refresh my memory. Was that exhibit number 42?
It was exhibit 42.
Okay, thank you. I've reviewed that. That was Montgomery County data request number 3. I understand Pepco does not have any concern or opposition, and I heard no opposition from any other parties. So Montgomery County exhibit number 42 is moved into evidence. Before we conclude, you're welcome. Before we conclude today, are there any matters that we need to address in advance of tomorrow? Do any of the parties or witnesses or the court reporter have any objection if we start tomorrow's trial at 9:30 in the morning instead of 10 a.m.? Only if you have an objection, please announce. Okay, court reporter is okay. Hearing no objection, we will reconvene tomorrow at 9:30 a.m. Eastern, April 29th. Today's session is now in recess until tomorrow morning. We'll see everybody at